not sitting
Yeah.
tomorrow.
Ah.
No urgency. You can come on 18.
Please
But
before
let an order because if on
before the
18,
assignment.
18 I will mention it again, it will be another one day.
Yes.
To prevent that thing only I made him mention.
Please sit before the assignment. Okay.
Pardon to mention
Yes.
on the same minute.
On 17 or 18, whenever.
17.
I don't know whether he's coming on 18th or not. Let it be 20th.
Then he's sitting for us.
17th, no, tomorrow. 17th.
Tomorrow.
18th.
Yes, sir.
18th.
To be safer side, let it be 2019. 19th, yes.
Pardon to mention, my lord.
One.
Assignment of court number 3, my lord.
Yes.
It's an urgent matter because the SSC has been selected. Women Self-Help Group has been selected for the month of December. Selected. Now they have given another advertisement to select another one, my lord.
For December.
No, for another one, my lord, because it is a term of 1 year, my lord. Infrastructure, manpower, everything has been
Okay.
developed, my lord.
18th.
18, my lord. Tomorrow, my lord.
Tomorrow, I'm not, most probably not holding. I may not be available tomorrow.
17th, my lord.
17th is tomorrow.
18th.
18th. That's what I'm saying. 18th. Yes. 18th.
Hon'Ble.
So, Lordship, may I beg your pardon?
Also come on 18 because this is a case where the option purchaser.
Yes, 18th.
So, it was assigned to court number 3 to GS Satpathy court, but it's the matter is next date before the learned court is tomorrow only. So, matter has to be taken up urgently before.
Tomorrow only. Tomorrow is there. It is to be listed.
Because the matter is in the family court tomorrow
What-
only. So, this is
All
about
right,
the
what will happen? It's
So-
a maintenance case.
yes, sir, maintenance.
So
case.
what great thing will happen? Yes. Yes, next. Any mentioning?
So, the date.
Pardon, item 160. My land and product on that side, only we have to file a written note of submission. He had also mentioned 2-3 times. I have also mentioned. I will. It will take only 2-3 minutes.
What do you want?
I pray it may be taken up.
Wait, I will take up. Let me go through the.
For that reason, I am.
No. Once I run through the miscellaneous list, thereafter I'll pick up. Okay.
If not reasonable,
Yes.
pursue my as a last matter.
I'll
before
take
writing.
it. I'll just.
Pardon to make a mention, my lord. My lord, one CRLMC number 3647 of 22. My lord, in this case, the petitioner has been enjoying the interim order passed by this honorable court. My lord, I am appearing for the OP. It has never been listed after getting the.
What is the date given?
My lord, it was fixed to 26/7/24. It was never been listed after that.
Give the memo, we'll see. Give the memo, we'll see. Give it to Jyoti, will check it out. Yes.
Lordship, press case for admission. It is not listed yet.
It will be listed. Okay, give the memo, we'll read it. Yes.
Belgium matter, your lordship.
Give Belgium 18th. 18th. Yes.
Item number 82, my lord.
Let us go page wise. Yes. Any mentioning? No.
Pardon, one
Yes.
mention. It's a press matter.
Press matters will come. Serially, those matters are coming.
Really, that's common. I give me.
Give the memo and see. Yes.
I have a mind. It is delisted. Another
Not D.
is a delisted.
Was it listed earlier?
Other my number is other numbers are crossed my number.
There must be some reason.
Well,
Yes, we'll see.
tomorrow.
Yes. List wise check दियो.
Page number 8, item 58.
नहीं 58 पूरा 8 रख दियो. पूरा page रख दियो.
58 to item 161.
Item number 65. Item number 65. Item number 65.
Page 9, item 59 to 66.
Item number 65 permitted to withdraw.
Withdraw. Permanent. Yes. Yes.
Page 10, item 67 to 80.
My lord, 73, my lord. Paying for adjournment, my lord.
73.
73. My lord, contracting counsel, Mr. Pratik Das is out of the town.
Oh, March. Yes.
Case 11, item 81 to 93.
Is item number 82. I
It
pray
is the adjournment also or the request of counsel for the petitioner.
82, my lord. I pray for an adjournment. Maybe list after that.
Same, counsel, March. Yes.
Case 12, item 94 to 105. Case 13, so 106 to 119. Case 14, item 120. Case 15, item 120 to 123. Case 16, item 124 to 131. Case 17, item 132 to 138. Case 18, item 139 to 142. Case 19, item 143 to 134. Case 20, item 145 to 154.
I think nobody is there. Oh,
My lord, may I pardon mention, my lord? My lord, item serial number 66, my lord.
What do you want?
My lord, it's short adjournment, my lord.
Huh?
Short adjournment, my lord.
Short.
Mr. is affected in
On the request, on the request, March. Go to March. Yes.
Item number 155 here. See,
Mhm.
the matter has been amicably settled between the parties matters.
Hmm.
And both the parties have given.
What are the offences?
Offences, your lordship, 420, 406 acts.
They've settled the dispute.
My
I'll bring it to supplementary.
lord.
I'll bring it to supplementary for 18th
For
or
your-
19th.
my lords, they have also come today, your lords. If you were to take it at 2 o'clock,
Okay, it's all right. 2 o'clock.
but information advocate is also there.
Okay. 2 o'clock. Bring the advocate as well as the party.
My lords, the advocate is present.
Yes, yes. 155 note kar rakho. 2 o'clock rakhiyo. Yes.
Pension by law. Lordship, one CRLMC 4450/2024. Matter has been already listed, Lordship. That day, Lordship, pass over my item. But in last, not taken up my item, Lordship. And
Password matters are always taken up.
Lordship,
You
that day,
You may not be there, so therefore it is urgent.
no, Lordship, that day not taken up, Lordship. And
Doesn't happen
matter
anyway.
has been posted to Lordship 3/3/2025, Lordship.
Because nobody appeared. We are very careful on that.
Yes, Lordship, but that day,
That day I don't remember. I'll have to see the footage now.
Lordship,
YouTube
I've already
footage.
filed, Miss Case already filed.
You file an application for preponement and giving reason, I'll just do it. Okay? You file an application.
Yes, sir.
File an application for preponement of the date.
Yes, Lord,
Showing
already
the
filed.
urgency, then we'll do it. Okay,
Lordship, I already filed, Lordship.
okay, it will come. Great. This is application for preponement.
Yes.
What is this application?
Lordship, application is CRLMC. There is the matter relating to
What is the application you have moved right now?
Report of the.
Huh?
reports to hearing.
Preponement. Preponement of the date. She is
I'm going
talking about
I
something.
have-
You be sure what application you have moved.
Yes, Lordship.
I know, yes. I'm not asking yes or no. I'm asking what is that application you have moved?
Early hearing, Lordship.
Preponement is early hearing only.
Yes.
Please.
I mean, pardon, my lord, in the cause list, it has been indicated that item 187 will be taken up first. Mr. Maharana has not seen the list and not brought the file. So he requested me to mention before your
Okay.
lordship.
I'll take it up after 3 o'clock.
In the top of the list.
I know, I've seen that. I've seen.
So
Okay.
it may be taken up any other day. Mr. Maharana is coming.
Yes, let him come. Yes.
Item 58.
Complete 58. 58.
Matter of settlement.
Huh?
Matter of settlement, your lordships on last Friday directed that parties should be present.
What are the offences?
Offenses 419, 420 and 60.
59. Your my lord, 360 is there, my lord. So.
Notice is to.
First, my lord.
Okay.
Section
I
14.
need to notice.
ST नहीं हो.
Huh? No, information. SC is there.
Well, it was in the first information report. Charge sheet has not been submitted under 3S.
But there is ACSP.
I'm giving the charge sheet.
Charge sheet has been filed.
No, trial is going on. I am challenging the order 311.
Final form amor
311. Okay.
SCST is there, my lord.
It's there. Sorry, sir. It's there.
Then I'll have to issue notice.
Also, it was not there, but SCNST is.
Let us issue notice.
My lord, please.
Issue notice. Issue notice to opposite to the victim. Victim opposite party. Opposite party number 2. Opposite party 2. Returnable also. It petitioner is agreed by the order dated 7/9/2023 passed by learned ad hoc additional decision sessions of the FPSC 1 Jajpur in city case number city special POXO case number 12 of 2018, whereby his application under section 311 CRPC for recalling PW 1, 2, and 4 has been turned down. Has been turned down.
Well, let me see what the notice will be issued. Let me say section 15A of the Act. 15A force, my announcement is pointing out 5. A victim or his dependent shall be entitled to be heard at any proceeding under this Act in respect of bail, categorized in respect of bail, discharge, release, parole, conviction, or sentence.
Or an accused of any connected
Or
proceedings or
sentence.
arguments and file.
It's coming under connected proceeding.
Any connection.
Let it be.
Let it be hard also on this point also.
Issue notice, written also. And in the meantime, the petitioner may move an application before the trial court for seeking adjournment, owing to the fact that the matter is sub judice before this court. So, first week of January. First week or second week? January? Second week of January.
Yes. Stay there.
Yes.
Item 60.
May I please your lordship.
In the last occasion, the lordship had taken with you that we have filed 5 cases for under OPID Act to challenge
OPID. I'll pass it over. Pass it over. Let OPID. Yes.
Item 61.
My lord, I am the complainant, my lord. In 138 NI Act case, my lord. This case was filed on, my lord, 15/10/2022.
Yes.
Thereafter, my lord, cognizance was taken on 12/12/2022. Thereafter, my annexed.
What do you want?
My lord, say,
Expedite.
Yes.
prayer is there.
And NBW is not yet executed.
आज पर्यंत आज्ञा से 2022 रु
22 दिए.
हां 2022 रु गडुची आज पर्यंत से अपियर भी कले warrant
these are the offenses where the statute provides. Then
I've seen that, but 6 months is the statute provides. But if the accused will not appear, my lord, then proclamation 82-83 is there and will already.
You can't keep on waiting for eternity. Immediate
See again 82-83 petition, say court will take care of that court. 82-83 placing, my lord. If NBW is not carried out by the police, if he is not available in that locality, my lord.
There is an address issue.
Yes, my lord.
No, address.
No, address, my lord, ठीक अछि, but that NBW has not been executed. Initially, my lord, BW was issued. Thereafter, my lord, NBW was issued.
What court will do? Then 82-83 is there.
Thereafter, my lord, since 2022 till date, my lord, he is not appearing intentionally and deliberately. For that reason, this present petitioner before your lordship for a direction, my lord, for immediate action, my lord. For
which provision is that? It says
your lordship 82, your lordship may kindly reply. 82 of the CRPC.
No, that's right. But NI Act, you tell me.
NI Act, my lord, that is.
Which provision is that?
6 months. So that's it. That's it. You can become later.
Which provision is that? Say, tell me the provision.
Yes, my lord.
6 months, I know that, but I
Okay.
want the provision. This is minimum. You should have come with
Yes,
the
my lord,
provision
that's
at
it.
least.
I will.
Tell me which is the provision. Pass out. You come with the provision. Yes. Pass out. Next.
62.
All every provision of law also you will read here. Research also you will do here.
My lord,
Yes.
My lord, 143(3).
143? Yes.
Because the
Yes,
trials of
right up.
offences under the NIA
Right.
will be concluded within 6 months from
Yes.
the date of filing.
143, yes. Petitioner is the informant in ICC. What item number? Which one?
This is item
62.
number
61.
61. Yes. Petitioner is the informant in ICC case number. Where is that?
This case number.
ICC and
that is
NI at
history,
25 of 2022 for alleged commission of offense punishable under section 130 NI 8. So the petitioner had initiated this 160 case number so for alleged commission of offense under section 138 NI 8 against the petitioner. The when have you filed the petition? When have you filed the complaint?
My lord, that complaint petition, my lord, I have filed on that is 15/10/2022.
15/10/2022. Though the cognizance of offense
And cognizance was taken on 12/12/2022.
12/12/2022 and
That's 9.
process has been issued against the opposite party number 2, but the service of summon has not yet been effected on the opposite party number 2. Subsequently to the trial court, although has issued a stringent process for ensuring the presence of opposite party number 2, it is contended by the petitioner that opposite party number 2 is deliberately avoiding the notice. Hence, he finding no other way, he has filed the present proceeding before this court, seeking direction from this court for expeditious disposal of the complaint case. Section 143.
Subsection 3.
Subsection 3. Subsection 3 of section 143 of NI Act mandate for expeditious disposal of all the complaints instituted under section 130 and outer time limit of 6 months has been provided. Keeping in view the mandatory provisions under the Act, the prayer made by the petitioner appears to be innocent, and deserves attention. Deserves attention. Next, regarding what will be aforementioned, the petition is allowed. The trial court was directed to take all necessary steps to ensure that the trial of the 160 case number so is concluded at the expeditious possible. Yes. Yes. Next.
Item 62.
Pass out.
Item 63.
May I please, Lordship?
Yes, madam.
NPW. NPW order against 19/1/2023.
Yes, NBW. Yes, Mr. Jana.
But this is, he was not enlarged on bail. Your lordship's previous orders, your lordship may kindly glance. Once he has stated 41A has been complied. For that reason, my lord, the case was disposed of. Subsequently, that was restored, recalled. And he was file is not but the order shows he was a bail he was so your lordship's direct
Before that-
surrender and in accordance with law the bail appeals.
Where is that order, madam? NBW.
Annual order.
NBW 19/1/2023
When petition is agreed by the order dated in 19/1/2023, passed by Learned JMFC bracket R Baleswar, whereby NBW NBW has been sued against the petitioner for his absence in the court, absence in the court despite service of notice. Counsel for the petitioner instruction subject for the execution of NBW states in 31st. Yes, allowed. Yes.
Object.
Next.
Item 64.
4 Millards may kindly be adjourned to Friday, Millards.
You don't select the date, it will go to March.
That's a
No,
fresh matter. My senior is on his legs in another
And the
court.
request of the learned counsel for the petitioner leaves the matter.
Let's kindly pass it over then, Millards.
Pass over. Next.
I'm grateful, Millards.
Yes.
Item 67.
Wait, please, Your Lordships. That's item 67 and item 70. They arise out of the same dispute. I would request
67 and 70.
70.
Yes.
I would request your Lordships to have item 70 first.
70, okay. 70. 67 and 70. Huh?
And 70,
Okay,
both
70.
matters.
Okay.
In item 70 minutes, here the FIR is under challenge, under page 33.
Yes.
If your Lordships peruses the FIR, FIR has been registered under section.
What is the stage you tell me?
Millards, here investigation is in progress. Investigation is in progress. That was the last instruction that I had before filing of this application.
Yes.
And in 67, cognizance has been taken.
So come to cognizance, forget about that. Come to cognizance.
Millards. Before that, Millards, I would like to.
That matter has gone now. It's lost its sanctity now.
Millards.
Right. Yes. Come to 70. 69.
67.
67.
Page 30 is the
Come to the cognizance order.
Yes, 30, my lord.
30.
Page 30 is the cognizance order.
Yes.
Received CS number 313 dated so and so is received from the IO against person namely Saroj Sethi, Somaranjan Sethi, Dhaneshwar Jana, Santa Harichandan, Rabindra Harichandan, Kondo alias
Yes.
Sambrahma, so and
Yes,
so.
don't read it.
Cognizance has been taken under 448, 294.
Who are you? You are.
I am for the
all of them.
petitions.
All of them.
All.
You come to the allegation.
It has not been filed. Charge sheet copy.
Yes, charge sheet. Show me charge sheet.
Charge sheet not filed.
Charge sheet copy to file.
Then what have you filed?
What is
Cognizance order you are challenging, you have not filed charge sheet.
FIR there cognizable offenses, madam. Yes,
Sir, so far as item 70, 70, the petitioner has filed the present petition seeking quashing of the FIR number so. After investigation, charge sheet in the present case has already been filed on
69.
charge sheet filed on
The filed on 16/10/2020.
16/10/2020. Yes. Thereafter, by the order dated
23/11/2020.
23
23/11/2022.
23/11/2022, letter
20.
20, Lieutenant SDGM Khurda has already taken cognizance of offenses punishable intersection so and so page 30, so and so against the present petitioners. Petitioner. Therefore, the instant petition has become infructuous because the petitioner has already challenged the cognizance order dated 23/11/2022 passed by CGM Khurda by filing MC number 3923 of 2024. The title of this CRMC is Khurda. 70 days. Insofar as the 67 is concerned, the counsel for the petitioner seeks an adjournment to place on record the copy of the charge sheet and let him do so within a week, leaves the matter in the second week of January. Yes.
It's item 70, it is not out of the same FIR. It is a different FIR.
नहीं these are 20 रो ये भी charge sheet
You say connected matter. Same FIR.
Dispute the same on charita का FIR है जो सेटा अपन को lordships को नाम नोटिस को आने को No, say it's the same.
You have told me that is there is not same FIR. Here cognizance order I am challenging, there FIR I am challenging. Therefore I wrote that.
I'm sorry, I was misunderstood. I was misunderstood.
Both the matters adjourned to second week. You have not filed full documents. Yes.
Item 68. Item 60 may be taken the OPID advocate as.
Wait, pass it over. I have already passed over your matter. Yes. Next.
Item 69.
Yes.
Item 69. Basically, your lordship, I mean the VC, my lord.
My lord,
68, what happened?
68 I'll take it up after vacation.
What do you want?
After vacation.
After adjourn on request of legal counsel for the petitioner. Adjourn. Yes. 69.
Item 69.
69, my lord. I am the VC, my lord.
Yes.
This is a matter praying for fresh investigation and re-investigation, my lord, because the petitioner, she was a student. She belongs to a remote area that is Raigada district and got in love with a man and was married to a man who was from Jagat Singhpur, my lord. Thereafter, there are a statement that she was not been accepted in the in-laws house because she belonged to scheduled caste community. And therefore, because of outcast and the boy was from upper caste, there was no family conciliations and the boy was not taking her to this his house.
Yes.
Thereafter, after so many months or years, they stayed outside because both of them were studying in the same college.
It's all right. What happened to your FIR?
FIR was being registered, my lord. The FIR copy is page number 20.
Yes, I got it. You tell me that what happened to the FIR, whether investigation completed or not?
Investigation completed, my lord. And thereafter, the charge sheet was submitted and so many important sections were deleted. The charge sheet was submitted.
Where is the charge sheet?
Page number 80, my lord.
80.
From 79.
80.
Yes.
In the last paragraph, 498A, 294, 323, 34.
80. 1 minute, sir. 1 minute. 1 minute. Where is the charge sheet? Yes.
Page number 80, last paragraph, my lord.
Yes. It starts from.
Accordingly, as there is prima facie.
Accordingly, as there is prima facie evidence well made out under section 498A, 294 and 294, 323, 34 IPC and 31 RS and SCST Act. The important one is for VA, my lord. Whatever, even though the charge sheet was.
Why are you aggrieved? The charge sheet has been filed already.
The filed protest petition not
why how are you aggrieved? You tell me.
I'm telling, my lord. The plain paper FIR says that she was being forced to commit suicide. And thereafter, she was also repeatedly pregnant. She has been terminated.
Husband under section 498 and 296. Protest petition has been filed, Annex 3.
Yes.
And the basing on the protest petition, the learning magistrate has taken cognizance against all the accused person in all other offences which is there in the FIR. In fact, we don't state
material might have come on record. What to do?
No, my humble submission. A talk of compromise is going on.
I'll simply issue notice. Let us issue notice. Matrimonial dispute unnecessary.
Left to 498 and 294.
Yes. Issue notice to opposite party number 2. Written also. This being a land counsel for the petitioner submits that the initially, although the FIR was registered against the FIR registered by the opposite party number 2 against her husband and all the in-laws. However, after investigation, charge sheet was filed for alleged of commission of offence punishable under section 498A oblique 294 IPC against the husband of the opposite party. And number 2, agreed by the same, the opposite party number 2 filed a protest petition. On the said protest petition, now the cognizance has been taken by the which court?
It is Jagatsinghpur.
By the SDJM JS Food, Jagatsinghpur, by the order dated 16/12/2023. Petitioners are agreed by the same. Then counsel for the petition submits that since the dispute is arising out of a matrimonial discord, the parties are likely to settle the dispute. And hence he is praying for issuance of notice to opposite party number 2. Issue notice to opposite party number 2, written also in the internagnum, the proceeding before the court, proceeding in ICC case number 43 of 2023, pending before the SDJM Jagatsinghpur is stayed till next date of hearing. Shall I send it to mediation straight away?
Let the lady appear. It will better. Then they have to send it to mediation.
Item 72.
File the process and all. Huh?
Process, madam.
Yes.
By tomorrow, by day after tomorrow.
Yes.
Item 72.
72.
May I please, your lordship?
Yes,
And
madam.
Item 72 and 74 arising out of same affair dated 8th August 2024.
72 and 74.
74.
Yes.
The sections are 308(2), 296, 351(1), and section 3, subsection
In
5.
72, what are you asking for? Quashing of FIR?
Yes,
There is
yes,
Act 2
your
is filed in
And
affidavit.
74, what are you asking?
Same, your lordship, because it arises of
On the
Quashing
ground of settlement, Annex 2 is filed. The informant has given to the police that matter is settled. Actually, basing upon Annex 2, my learned friend is seeking for quashment.
Which item you are talking about?
72 and 74.
72 and 74.
Why have you filed 2 petitions? That's what I'm asking. Prayer is same.
Accused persons are different, your lordship.
Okay. Jayant Kumar Sahu in this petition and the other petition?
Your Lordship, Kartik Chandra Jana is the 72 item. And
They have settled the dispute.
that is Annex 2, your Lordship. Page 15.
What are the offenses?
3082, your Lordship. Extortion, your Lordship.
Lordship, it arises out of the Durga Puja, at the time of Durga Puja only. The collusion arose and it has been settled at that time only.
Yeah, what are the allegations? Tell me first.
Allegations regarding Dada Bhatti.
Like 10 lakh taka mag chanda magile, your Lordship. That is page 13, your Lordship.
Yes. Read the allegation.
Your Lordship, किंतु कारणवशतः रिलेवेंट है किंतु असाधु असामाजिक लोकଙ୍କୁ आनी मोर राजा बगीचा मंडप रे मारिबाकू उद्यम करबाकू आसीथिले किंतु कारणवशतः मो किछि काम रे बाहरी पर जाउथिले कुमार गौरव साहू एवं तांकर सहित आउ 8 जन प्रचुर मद्यपान करी मो स्टाफ एवं सिक्यूरिटी को गाड़ी ग्लास देबा सहित मते जीवन मारि देबाकू धमक देले एवं तो मालिक को डाक से कुआडे गला सो एंड सो लैंग्वेज 10 लाख टंका चांदा देबु जदी भलरे न दिए मते किए से हानि जानिबो मते किए से जानिबो तो मालिक को कहि देबु जदी भलरे टंका देई देबो ताले भलो नहले कॉलेज को घरे बसी मारिबु ओ ता जीवन को जदी
where are they madam? Informant and accused.
Yes, sir.
Bring them.
Let issue may be noticed so that they can appear and settle the matter.
Sorry?
Issue may be noticed so that
No. I will not issue notice. Why should court will issue notice? If you have settled, bring them.
Yes, sir. Lord. So next date I will.
Okay. So, 23rd. 23rd. Yes. 23rd. Both the matters. Yes.
Item 75.
What 73?
75. Requestment of proceeding, your Lordship. 341, 294, 323, 506, 34, your Lordship. Charge has been filed.
What are the grounds?
29,2024
I'll just pass over. Okay. Yes.
Item 76.
May I please, your Lordship, my lord?
Yes, sir.
My lord, in this case, the petitioner challenging the DB proceeding on the ground that the learned magistrate are not surely failed to consider under section 12 of the said act, your Lordship. Lordship, in section 12 of the said act is that application to the magistrate, an agreed person or a protection officer or any other person on behalf of the aggrieved person may present an application.
Tell me what.
My lord, my humble submission is that once the
Who is said Kreta Chaudhary?
my lord, that is the wife of the petitioner, your
Then how
lordship.
it is not maintainable?
What on this sense, your lordship, the learned magistrate should have called for the social report. Section 12, lordship, kindly see.
Yes.
Lordship, after obtaining the petition, the magistrate should have provided before passing in order on such application, the magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider, your lordship.
Yes.
So without awaiting the incident report, the learned magistrate proceed the matter, your lordship.
Yes.
Apart from that, your lordship,
Have you moved any application before trial court?
I have filed the written. I have filed the WS, your lordship. In that WS, we have taken a ground that this petition is not maintainable.
What happened to that?
That's why he has not passed an order, issue notice.
You move application for dropping the property. There. Why have you come to 482 court?
As because it's a matrimonial matter, we should not want to proceed lingering.
It's all right, you move application, it is not maintainable. Have you questioned that maintainability there?
Yes, in our WS we have.
Then it will be considered. It is premature. I can't convert myself to a DV court now to consider whatever stand you have taken, that has to be dealt with by the court below. I'll just direct the trial court to deal with the objections as expeditiously as possible. Right. Petitioner is agreed by petitioner is the husband of opposite party number 2.
Yes,
one. Number 2. 1. Next further. The opposite party number 2 had initiated a proceeding. Initiated a proceeding under section 12 of DV Act against the present petitioner and other in-laws. The counsel for the petitioner submits that the trial court has proceeded with the matter without obtaining the report from the protection officer. Therefore, the petition is the foundation of the petition is vitiated. Hence, he is seeking in the Supreme Court. He further submits that he had already filed a written statement before the court below, raising all these points. However, no specific application has been moved by the petitioner before the court regarding the questioning the maintainability of the DB proceeding initiated by opposite party number 1. I am not inclined to entertain this petition at this stage. However, the trial court below is directed to deal with the objections raised by the petitioner in the law as expeditiously as possible. With this observation, petitioner. Yes, next.
Item 77. My lord, 75 after vacation. 75, my lord.
75 what?
Pass over.
March, on the request of petitioner, please March. Yes.
Item 77.
The petitioner filed this application challenging the order of challenging judgment of the learned session judge passed in division number 2224 on dated 13 September 2024.
Yes.
The learned session judge dismissed the revision petition on the ground of maintainability matter. Stated that the revision is not maintained.
39. Where is that order?
Next year, 4 page 29.
Yes. Yes.
Operating part. Para 7, page 33, last para 7.
What is this order 4/5/2024?
Lordship, that is the order, legal order, my lord. 311 petition has been filed, that has been allowed. The order, can you see page 21, my lord.
21.
21. Order dated 4/5/2024.
Who are you, by the way?
I am the accused person, my lord.
You are the accused.
Lordship.
Whose application was allowed?
Complaint case filed Suchitra Barala, the complainant. One second case was filed by the complainant. I'm the accused person in the case. After completion of evidence, recall petition has been filed. 311 petition has been
By the complainant.
to lordship.
Yes.
On 4/5/2024, the recall petition was allowed. And says the page 23, the operating part.
Yes.
Allowed.
Whether this is the final order or interim order?
This is the interim order.
Interim order.
Introductory order.
If it is an interim order, revision doesn't lie.
The interim
What is the principle for filing a revision? A final order, if appeal is not provided, revision lies. This is the principle. If it is interim order, how will you file the then?
To that effect, the Supreme Court judgment was there. That has been. Then evidence was closed.
Yes. Which paragraph, sir?
Paragraph.
Which paragraph of the judgment? Which paragraph?
Last.
Does the judgment say that revision lies?
Lordship.
Where is that? Which paragraph?
Lordship. Though
which paragraph of the judgment? Pass it over. What is this? You are bringing mobile and searching like this.
Sorry, my lord.
This is you have. I think you forgot that this is High Court.
No, my lord. Copy one to be there. Pass to Quashing.
Item 78.
Yes.
May I please, your lordship? The petitioner has filed this 482.
Yes.
Quashing of the entire proceeding which was initiated against the present petitioner along with another in the year 2013. Your lordship may kindly see the FIR.
You are the accused.
284,
Entire quashing proof.
He is asking for quashing. Yes. Yes.
That is a case of in the year 2013. Your lordship may kindly see the
What is the stage now?
only charge sheet has been submitted. In the meantime, the departmental proceeding was initiated against me and I have been exonerated from the charges. That is under Annexure 3.
Annexure?
Annexure 3.
Page 21.
Yes.
Running page 21. The charge levied against me was already exonerated by the director. In a similar decision, your lordship,
Yes.
similar decision, the proceeding was
Exonerated.
quashed.
What is this Annexure 4 PC case number?
ଗୋଟେ complaint ଯୋଉ complaint ପାଇଁ case file କରିଥିଲେ ସେଇଟା
Filed another, that is not relevant to this, but somehow that was annexed. But the annexure.
No, it's not at all relevant.
Not at all. The complainant informant has filed a consumer case against the present petitioner along with the inspector in charge for negligence in duty. That was also dismissed. That is the document.
Okay.
But in the departmental proceeding, I have been.
Oh, that is dismissed on default. Nobody appeared. Yes. Not relevant. Yes.
No. And in a similar decision, when the departmental proceeding has already been filed, with the permission of this court, the proceeding may be passed. A decision that
I am considering that.
lordship
Much water has flown after that. Much water has flown. Okay. This is no more. This is under consideration. I will simply issue notice. We'll see. Simply issue notice. Let us see. Because the Minakatan is under consideration by this court only. Yes.
But in the departmental proceeding, I have been.
That is the whole argument. Exoneration in the departmental. See, standard of proof is altogether different. Criminal case standard of proof and the departmental proceeding standard of proofs are different. So therefore, once you are exonerated in departmental proceeding, doesn't mean that the criminal case will not go.
Your lordship may kindly see the FIR running page 11. Even if accepting, I am a staff nurse. It was alleged by the informant that while a saline was going on, the saline was somehow disturbed. And accordingly, he lost the affair, he sustained pain in her body, in his body. That was the allegation. But what allegation I have neglected in my duty? No allegation to neglect my duty.
78 plan.
Yes, sir.
78 ସେ administered जो saline ଟା ଦେଲେ ସେଟା ହଉଛି expire ହେଇଥିଲା ଦେଲା
କେମିତି expire? This is the allegation.
sustained various pain your lordship. Therefore
He, what is he?
yes your lordship, she is the staff nurse. Now
What she will do? Doctor has to chat what will
say
doctor might have instructed कि saline दे दे she was काम खत्म ठीक हो गई थोड़ी
both the options are available in the child lordship. 14 से exam हेलेनी department proceeding रे 24 रे आछन
10 वर्ष ला you have not done anything, that itself is a ground for quashing.
That's right.
Yes. Who, why don't you bring up, we'll consider and quash it, why should the unnecessary court who is Jyoti Prakash?
The informant, he is the victim also.
Bring him first week of January, and if I stay, then you will not file, this will be pending for another 10 years. That's the whole difficulty. You bring him, I'll pass it.
Maybe come or not. That was
I'm issuing notice, bring him so that I can quash it in his presence.
only notice may be issued.
Notice. Next is the only notice. The moment I'll give stay, then you will neither you file process fee, you send your junior for adjournment.
No,
10 years this matter will be pending.
No, my lord, I will be in course of the day.
First week immediately after vacation, 7th you bring him. File the process immediately. 7 को 25 लगाओ and process to be filed.
In course of the day.
No, I'll quash it. If service is not even complete, I'll quash it. Yes.
Item 79.
This is for passing of proceeding on the ground of who are acquitted from the charges.
Yes.
Can you see the running test?
You are absconding.
Yes, ma'am.
Yes.
Running test 33.
30?
33, ma'am.
Yes.
Test para 15, my lord. Because mandatory provision of 42 was not complied with, for which my lord who are acquitted. 33.
Yes. How many accused persons are there?
2, ma'am. One was acquitted.
One acquitted and you, or and one more is still absconding. That is the whole difficulty. Installmentally, one after another will come.
2, one acquitted, this benefits.
I'll cancel the NBW, go 3 months. Okay.
So in this case, what happened? The petitioner arrested on ethic and escaped from the police custody.
I know, I see.
Yes, your lordship.
Just now I saw.
Difficulties, your lordship.
So therefore, you were waiting till your friend, you remain outside, you manage the witnesses, got your friend acquitted, thereafter you are I'll stay you appear on or before 31st of December, and within 3 months the trial will be concluded. Okay. Petitioner is seeking quashing of the entire criminal prosecution initiated against him in connection with the FIR PS Patapur PS case number 145 of 2001 for alleged commission of offences punishable under section 20B1 of NDPS Act. After investigation, charge sheet has been filed in the present case on 11/11/2000. Charge sheet कब फाइल है भाई? On 11/11/2001. 11/1/2000. The petitioner was you are on bail.
No.
Absconding.
Police custody to escape
petitioner has been absconding. It is alleged that the petitioner was in custody and escaped from the custody. Therefore, by the order dated 12/1/2001, NBW has been issued against the petitioner, which has not yet been executed. Meanwhile, the co-accused who was apprehended faced the trial. The learned special judge come second additional session says Barampur Ganjam by its judgment dated 7/8/2015, recorded in acquittal in favor of the co-accused person. Relying upon the acquittal order dated 7/8/2015, passed by the 11th Special Judge Barampur in the case of the co-accused person, the present petitioner is seeking quashing of entire proceedings. For the petition, the counsel for the petitioner is extensively read out the judgment and submitted that mandatory provisions in the judgment have not been complied with. Therefore, the trial court recorded acquittal in favor of the co-accused person. Hence, subjecting to the petitioner or to the rigors of the trial is destined to be a futile exercise. Futile exercise in view of the non-compliance of the statutory provision under NDPS Act. Since the petitioner has escaped from the custody and the NBW was issued on 12/1/2021, I'm not 2001. I'm not inclined to entertain the petitioner at this stage. However, liberty is granted to the petitioner to appear or surrender before the court, surrender before the trial court on or before 31st of December 2024, and resort to the remedy available to him under law. Regarding had to the fact that the petition, the present case is pending since 2001. Trial court is directed to do well to see that the trial is concluded as expeditiously as possible, preferably within a period of 6 months. Yes. I have recorded everything. That yes.
Item 80. My lord, the prayer. Sorry, my lord.
Yes.
Yes, my lord, the prayer is to quash the entire proceeding.
Yes, sir.
Against the petitioner, my lord. Let's say before going to the factual details, the more question, my lord, involved in this case is that this, my lord, entire proceeding is against the judgment of the Hon'Ble Court that is placed as the statement. This petition, my lord, is not supported by any affidavit. I've included the petition in Annex 1 series. It starts at page 13. But you can see.
Yes.
Yes, 17 and utility verification. Last minute, page 18 is the verification.
Yes.
Not supported by affidavit.
18.
Page 18, my lord. Kindly see.
1/8.
Annex 1 series, page 18.
Yes. Priyanka Srivastava.
Yes, you lost. That's right. You lost. But here is the case: the present person is the owner of the vehicle by having that.
Married, he is asking for Priyanka Srivastava not complied.
That's.
Who is the informant here?
Informant is Subodhan.
You are not implemented informant.
Not
This case arising out of a complaint. You have to
enter commercial transaction is that.
But whatever you have to implement, this is arising out of a complaint case.
Yes, ma'am.
Where is the complainant?
Complaint is the lordship is.
He is not. He is not.
Not implemented. Yes.
Who I issue notice then? He is implemented first of all.
Yes, I told them that the petition it is a.
The present petition is arising out of a complaint case. However, the petitioner has not implemented the complainant, public informant, hence he seeks leave of this court to implead the opposite party, implead the informant as opposite party number 2. Leave is granted. During he may implead the complainant informant as opposite party number 2. Opposite party number 2. Next paragraph. During the course of the day, you do. The counsel for the in the present petition, petitioner is seeking quashing of the entire criminal prosecution. What is this order?
The order there is stated that
12.
That is,
what is this order?
Page 21.
Directed for registration of FIR, lordship. 163 line magistrate has directed for registration.
Petitioner is agreed by the order dated 12/10/2020, whereby the court, whereby the learned SDJ Malkangiri, while entertaining the complaint of the part number 2, have directed the police to file, investigate and file a report under section 156 bracket 3 of CRPC. The counsel for the petitioner taking me to the complaint has pointed out that with the complaint there is no supporting evidence filed by the petitioner. Hence, relying upon the judgment of Priyanka Srivastava and so on, so he submits that the complaint is, indeed was not entertainable. However, the learned court below not only entertain the complaint but also pass the impugned order. Issue notice to the newly implemented opposite party number 2 written this second third week of January. In the meantime, learned counsel for this. This was into 2020. What had happened now?
Well, the appearance of the petition is fixed on 20th.
Huh?
The appearance of the petitioner is fixed on 20th of this month.
20th. In the meantime, the counsel for the petitioner is granted liberty to move application before the trial court, seeking an adjournment as the matter is submitted for this court. Yes.
The petitioner is a
immediately you implead.
Yes, but he is a widow and after there is a lawyer. This after death of his husband, he is now practicing or she is also practicing.
Everything is all right, but you file an incomplete petition.
I apologize for that.
Yes.
Item 81. The final adjournment application.
Yes, yes, that I've said. Yes. Despite you have filed an incomplete petition, I have given this much. But during the course of the day, please do it. Huh? Yes.
Item 81.
May I please, Your Lordship?
Yes, sir.
I may be allowed to place this matter, my Lordship, on behalf of Mr. P. Naik, my Lordship.
Yes.
Miss P. Naik, my Lordship. My Lordship, that the present petitioner, along with the other petitioner, challenge the order dating of cognizance dated 21/9/2023, passed by the Lord and Trial Court, my Lordship. That wherein the case was lost, my Lordship, the investigation agency filed the final report as a false one, my Lordship. After the investigation report that, my Lordship, the present complainant filed the protest petition, and due to the protest petition, the cognizance was taken, my Lordship. The my Lordship, before going to the contents of this case, my Lordship, I may be requested, my Lordship, kindly have a glance at
the cognizance order.
Yes, my Lordship.
Where is the protest petition for me?
That protest petition is not filed, my Lordship, the file.
What will I read then?
That I am the present
protest petition 202 statement you give me, then only I can understand whether rightly cognizance is
that along with me, what not in the file.
File it. You don't file it. That's the only document you are supposed to file. How have you filed this petition then?
If my Lordship, with my Lord's permission, I may
no, I will not read like that. Now there are a lot of problems. Online everything is happening and you don't throw the paper and expect
that same is ground. The taken in FIR, same ground.
That's right, but I need to know what is the protest petition, what is the statement under 202. Thereafter, I'll come to the conclusion whether cognizance is rightly taken or not. Cognizance is taken on what?
Except
cognizance is taken on what?
Cognizance is taken on only the ground of only the basing the statement of the complaint.
Where is the statement then?
Yes, madam. The statement of file.
Record ଦେଖାନ୍ତୁ ମୁଁ କୋଉଠି ପଢିବି କୋଉଠି ପଢିବି
then Malsu kindly to
the petitioner is seeking quashing of the order dated 21/9/2023 whereby cognizance of offences punishable. I don't know what is, where is that order you have you filed the order or not?
31.
Thank you that you have filed the impugn order at least. Of cognizance of offense punishable under section 31. And counsel for the petitioner submits that the cognizance has been taken on the protest petition and the inquiry under section 202 CRPC. However, surprisingly, neither the complaint protest petition nor the statement recorded under section 200/202 CRPC is placed on record. Hence, the matter is adjourned to the third week of January. Yes.
my lord.
Item 83.
Obliged, my lord.
I have passed that order, sir. During the course of the day, you do it, otherwise all the order will go. I have issued notice. You file, do whatever. You file this kind of petition, just see, cognizance order is challenged, nothing is filed. And take out something from the pocket and give it. This is the level what to do. If you don't file the implement application, then
I have to call.
the order will also go.
I have to call the party, my lord, which is from Barum.
I don't know what to do. You tell me, is a petition arising or the complaint, is the case arising out of a complaint case?
Yes,
The complainant is not there. What will he do? Sir, what can I do? Not today, so then day after tomorrow.
Day after.
Read by day after tomorrow. Yes.
Item 83.
83, may I please, my lord, I am the owner of the vehicle. Lord, kindly.
Sorry?
My lord,
What do you want?
my lord, only want for a direction of early disposal. My lord,
Who are you? You are the accused.
I am the truck owner.
You are the complainant.
Complaint. Truckটা রিলিজ করে ଦେଇଛନ୍ତି କିନ୍ତୁ 2015 ମସିହାର କେସ୍ ହେଲାଣି early disposal
What are the offenses?
Offensive, my lord.
Who are you? Are you an accused or informant? Who are you?
Informant.
Are you informant?
No. I am the owner of the vehicle.
However, you are not a party to this proceeding. Neither the complainant nor the informant. You are
the accused.
No.
You be sure about.
My lord.
You even
arising
don't know
out of a
whether you are a
160
complainant
case.
or whatever.
My lord.
Who are you? Are you an accused or are you a complainant?
Accused.
No,
So I am the owner of the truck.
the lordship kindly turn to page 13. He is the complainant informant. Page 13.
You first decide, sir. 13.
Page 13. Name of the address of the complainant. The Tajmul Haq.
Tajmul Haq.
And he has filed the petition for 452 for selling out his truck, and that was turned out.
Sir, I think you have not read it.
My lord. My lord.
Even you don't know whether you are accused or informant.
Sorry, my lord. I am the informant of the accused.
First you decide.
No, only.
I'll pass it over, decide it and come.
My lord.
Read it and come. I'll just pass you.
My lord,
Read it and come, sir. You have not read it. Please read it and come. I'll pass it over. I'll take it up at 2 o'clock. Read it and come.
Obliged.
Item 84.
Yes. Yes, sir.
My lord, in this case, my lord, petitioner has prayed for washing of the proceeding as well as a cognizance order.
Yes.
Cognizance order dated 4/8/23 under annexure 3 months.
Yes.
That is page 29 to 30.
Its CP will be required.
This is a case of FIR and a counter FIR by villagers of 2 different villages. And matter has been settled, and on basis of that, some co-accused has been released on bail also.
Where is that order? Bail granted, charge sheet. Where is the copy of charge sheet?
Charge sheet, your lordship, page 25.
20?
Page 29.
Sorry. Where is the charge sheet?
Vaccine.
Charge sheet.
Final form.
Charge sheet, I filed separately, ma'am.
Yes, separately he has filed. Charge sheet is filed. 341, 294, 307 is there.
It is simple in nature.
Have you settled the dispute?
That under annexure 5 I have submitted, ma'am.
Yes, and accept?
Under government 5, ma'am. That during investigation, the investigation officer arrested.
Where are you reading? Where are you reading?
Page 5, my lord.
Page 5 of your petition.
Ma'am.
Okay. Yes. Yes.
My lord, that during investigation, the investigation officer arrested Sheikh Iko alias Halaluddin and Sheikh Fazidun of Jakti and were sent to custody. Thereafter, they were released on bail by the London Session Judge Bhadrak in bail application number 340 of 2023 and bail application number 341 of 23.
Yes, they got bail. That's all right.
It's they were
They got bail. It's all right. But where is the compromise?
Compromise.
Where have you said that you have compromised or any affidavit filed?
And that
Earlier, your anticipated bail application was rejected. Thereafter, you were in custody. You have been granted regular bail. Okay.
My lord, in my case, my lord, I was granted bail by the Supreme Court.
That's right, but bail, granting bail is something different. You are seeking quashing of the cognizance order. You are saying that the parties have settled the dispute. Tell me, where have you said that or where is the affidavit?
The grounds I have taken.
Yes, which ground?
Page 10, ground number K.
Ground number?
K.
K. Where is the affidavit then?
My lord, I have not annexed it. I have not annexed that.
You have to file affidavit of information. You have to file. You bring them with the bring them. 3rd week of January. Yes. File affidavit, huh? File affidavit. And injury report also you place it on. Yes.
Item 85.
Yes, sir.
In this case, present petitioner challenging for passing of a proceeding man
Yes.
on the basis of a compromise. Unless there are three. Yes.
Page 20.
20. Okay.
Matter has already compromised.
Yes.
In between the parties out of court matter.
What? Show me the injury. 307 is there. What are the injuries?
That is no minor simple injury.
Show me that. Have you filed? Have you placed on record?
Simple injury, that is a dispute between two mothers, two blood related.
I understand it, but show me the injury report and just what are the weapon used by you? What kind of injury sustained?
Injury report is in there. Chassis is there. Chassis has already been filed. FR is minor 2006 minor. Before passing of a chassis minor, matter has already been compromised. On the basis of a compromise, the present petitioner are already released on bail under section 438 before this one court minor.
You have to bring them because this affidavit filed in 2006 somewhere.
Minor.
At the bail stage. 13/8/2006, the affidavit was filed by the injured, saying that we have settled the dispute. On that basis, you have been granted bail, isn't it? So now, on the basis of that, you want quashing up for the entire affair. Bring the informant. Let her repeat the same thing before the court.
Notice.
Generally, court will not be a party to this kind of petition. If you have settled, you have to bring them. I will not invite him by issuing notice. You get an affidavit from him because it is more of a reason to be quashed because this is a case of 2006.
Yes.
Nothing is moving. And in 2006 itself, the complainant has given an affidavit on the basis of which they were granted bail. So if that is the case, bring the affidavit and bring the informant and both of them to the court. I'll do it when do you want?
After vacation.
First week or second week? Second week or first week? Second week. Second week. Okay.
Item 86.
If you look at let counsel for the petition submits that. 1 minute, sir. I'll just note down those things so that counsel in the present petition is seeking quashing of the entire criminal prosecution arising out of PS case number 61 bracket 33 of 2006 taken over so for alleged offense under punishable under so and so. The after investigation, charge sheet has been filed in the present case on 48 answer the other sure for offenses punishable under section so and so. The while the petitioner were taken into custody, however, the informant in the present case appears to have filed an affidavit dated 18/3/2006 entirely stating that she has settled the dispute with the accused persons. On the basis of the said affidavit, and the petitioners were enlarged on bail. The petitioners are relying upon the said affidavit and seeking passing of the entire proceeding, criminal proceeding, on the ground of settlement and on the ground that the matter is not proceeding any proceeding since proceeding, although the FIR was registered in 2006. Issue notice to opposite party number 2, written so. I have issued notice. Yes. Yes. I'll just come. I'll just come. One.
The annexer 2 at page 64, LRC, the order of cognizance to 4624 is under challenge.
Yes.
Which is totally illegal and without material available on record, the cognizance has been taken for the offense under section 376(1), 366, 294, 342, 506, 109, 34 IPC, LRC.
Yes.
The fact remains, LRC. Annexer 1 FIR, LRC, kindly have a glance. The FIR registered against 3 persons, LRC. The FIR allegations at page 12, LRC. The allegations so far the present petition is concerned, Lordship. The victim is a 29 years old lady, Lordship. He alleged that one Sodesha Khora have a love relation with her 6 months, and thereafter they went away outside and stayed at one place. And while they were stayed at where they have a relation, and at that time, Lordship, the allegation that last 6th line
against him by the opposite party number 2 for alleged commission of offences punishable under section 403, 406, 420, 120B and 506 IPC. IPC. The counsel for the petitioner contended that by relying upon the comprehensive chart at annexure 3, by relying upon the comprehensive chart at annexure 3, submits that the petitioner has already made good the entire payments to the opposite party
On behalf of the company,
opposite party number 2 on behalf of the company wherein he is one of the directors.
Yes.
One of the directors. Without taking into consideration the payment aspect of the matter, the opposite party number 2 raised the FIR. Next investigation for the case is still going on. Therefore, I am not inclined to enter into the merits of the case at this stage. However, liberty is granted to the petitioner to appraise all these aspects to the investigating officer of the case, who shall deal with the same in accordance with the law at the time of filing report filing final form under section 173. With this observation, the petition will dispose. Yes.
Great.
Yes.
Item 88. Thank you, Doctor. Pass the one, maybe.
Password?
Item 89.
89, my lord. I have challenged the chat, the cognizance order, my lord. And the co-accused who has faced the trial, he has been acquitted. My lord, this case is squarely covered. My lord's judgment in Rakesh Chandra's house case.
Yes.
Annexure 3 is the co-accused acquittal order, my lord. Starts from page 21. Annexure 2, page 20, cognizance order against the accused.
Yes.
The newcomer who has faced the trial has been acquitted. And self-sub evidence, self-sub witness.
Chemical examination report was filed.
Chemical examination report. One second.
Yes.
That's page 53.
Yes. File or not, you simply tell me.
Hello?
Because you are relying upon this judgment.
Hello.
This judgment, I pass the judgment only on the ground that in the co-accused who has been granted, in that case, also, the charge sheet was filed without the chemical examination report. Therefore, the co-accused is acquitted.
Another thing, self-sub evidence.
No, you first come to this point. You are relying upon this judgment, then I'll not rely upon this judgment. You are not covered by this. First this, then second point. First point gone. Now come to second point.
Self-sub evidence. Self-sub.
That's not the issue. This judgment I have said, since the chemical examination report is not placed on record, subjecting to this petitioner for trial also will end in a futility. So therefore, I quashed it. But in this case, chemical analysis examination report is filed.
But the another thing, my lord, the paragraph 8 of my lord's with self-sub evidence co-accused acquitted. That is also there. Chemical examination report is there. But in paragraph 6, my lord, I have hold that. Taking into consideration the aforementioned facts, so I am the opinion putting the petition.
Come to page 26.
My lord.
26 of your petition.
My petition.
Read.
On his report.
Trial court judgment. On his report, IAS Gopinath Pradhan restored Mahmood PSK so and took up investigation. During course of investigation, examined witnesses, visited spot, arrested the accused. Arrested accused means co-accused who have faced it. Visited spot, arrested, produced in court along with the seized ganja products. As per the prayer made, 2 samples each category, 21 were collected.
All these things. And next, the sample A2, B2 and C2 and up to X2 were dispersed to HFSL Rasulgod for chemical examination under the seal cup and signature of the court. The investigating officer examined the witnesses, seized documents. Examination report is there. Chemical examination report is there.
Chemical examination report, as per judgment, had exhibit.
It is there. It is there. It is relied upon.
Is there, my lord. After my lord's query, I was verifying the exhibits marked, my lord. But the self-sub evidence.
That you have already said.
My lord.
You have already said that. What?
Self-sub paragraph 6 and 8 relying upon allowed High Court and Supreme Court judgment. My lord has told me.
Page 58, the exhibit P23, chemical examination report.
I have told that chemical, that has been marked, I have already told. But the self-sub evidence, my lord has.
42 is also not required to be complied with.
My lord.
That is also the finding.
My lord. 42 not complied with, and also co-accused faced the trial, my lord's judgment.
Where is the NBW?
NBW on the date of cognizance order, page 20.
Page 20.
Page 20, my lord.
You have been absconding, huh?
My lord.
Yes.
Page 20.
6 months. 6 months. Right.
My lord.
6 months you apply for bail and yes. Where is NPW rider? Petitioner is seeking quashing. Yes, I will fix the trial for 6 months. Appear.
He is not, NPW has been issued.
I'll quash it. NPW I'll quash it.
First and the.
Yes, I'll allow you to appear, not release on bail. You have been absconding. What is this? In a NDPS case, you have been absconding, release on bail. You have to appear. That's all. Right on. Petitioner is seeking quashing of for the FIR.
But I mean, pardon my lord. Another points also there. Is 42, 50, 54.
Don't waste time. I will not do that. Because in NDPS case, you have been absconding and you may be the instrumental in acquittal for the co-accused. Yes. Because you stayed outside and managed all witnesses.
Officer witnesses.
Anyway.
I play one thing, my lord.
Yes.
I play one thing, my lord. I consider it, my lord. My lord, the quash the NPW on surrendering, he shall be released on bail. Or while considering the bail application, the Lord Special Judge should consider that.
That I'll say.
Section 42, 50.
That I'll say.
That observation.
That observation.
That is suffice, my lord.
Petitioner is seeking quashing of the cognizance order dated 28/1/2022 passed by learned additional sessions has come special judge in special NDPS case number 41 of 2021, whereby cognizance of offences punishable under section section where is the cognizance order?
Cognizance order page 20, my lord. Order dated 28 January 22.
Yes, under section 20B to
28(1)
and 29
serial number
NDPS has been taken. 29 of NDPS has been taken. 20. At the same time, the NBW has been issued against the petitioner. Mr. Pandal and counsel for the petitioner submits that there are two judgments you are relying upon. What are the two judgments? Annexure 4, what is this? Annexure 4?
Annexure 4,
my judgment. Okay. Right. He submits that the co-accused Renu Kanhar faced a trial in the instant case. The additional sessions judge come special judge in Kandamar in a special case bracket NDPS number 41 of 2021 by judgment dated 40/2023 acquitted the co-accused. Relying upon the judgment she aforementioned relied upon the judgment dated 20th 12/2023 passed by the special judge Kandamal. The counsel for the petitioner submits that the petitioner may not be subjected to trial on the face of the quality of evidence adduced by the prosecution in case of the co-accused person. He submits that neither the mandatory provisions of section 42 is complied in the present case, nor the vital witnesses to the prosecutions have supported the prosecution. Hence, subjecting the petitioner to the rigors of the trial is destined to be a futile exercise. Therefore, he seeks indulgence of this court and pray for quashing of the impugn order. The petitioner has been absconded since 2022. Therefore, the benefit of the judgment of the special judge Kandamal in case of the co-accused Renu Kanhar cannot be extended to him at this stage. Having said that, I am for the considered review that the petitioner shall surrender before the court or not before 31st December also, and referred to the remedy available to him under law. It is open to the petitioner to move application before the trial court for grant of bail on all the grounds raised in the present petition. Petition. If such a application is moved, the same shall be considered on its merit on the same day. Needless to say that the case is arising out of an FIR registered in the year 2021. Therefore, the trial court should do well to see that the trial is concluded, the expediency is possible. Yes.
But I
With this, yes.
Confidence quash the NBW, and the NBW shall not be executed for a limit.
After quashing, not executed. Either quash or
No, not quashed.
subject to the
NBW
subject to the
still quashed.
subject to the petitioner appearing before the surrendering before the court below on or before the 31st. The NBW issued white order dated so in the state. Okay.
31st January.
31st January. 31st no, December.
Yes. Holiday is also.
Then holiday for criminal, there is no holiday. Yes. Next.
Item 90.
Wait, please, my lord.
And urgent
Actually, my lord.
Yes, madam.
My lords, herein the petitioners have challenged the order of cognizance at Annexure 4, my lords. Wherein
Yes.
the cognizance has been taken under 354B, 341, 294, 323, 506 by 34 IPC, my lords.
Yes.
My lords,
Yes.
there is talks of compromise being going on, my lords.
No, bring here.
Yes, my lords.
Oh, allegations are not very serious.
Yes, my lords.
You can bring her. Petitioner is seeking quashing of petitioners are seeking quashing of the order dated 18/1/2019 passed by learned SDGM Sundarkar in GR case number 752 of 2018, whereby the cognizance of offences punishable under section under section 354/323/294/323/506/34 IPC has been taken against the petitioner. Counsel for the petitioner submits that the parties have already settled the dispute.
The talks are going on.
Counsel for the petitioner submits that the parties are exploring the possibility of a settlement. Please notice to opening party. Yes.
Obliged, my
Item
lords.
91.
May I please, your lordship? Lordship, the petitioner are the accused in the GR case number 831 of 2022,
Yes.
20, which is pending before the JMFC 3 fact taking court. Petitioner number 1 is the house owner, and petitioner number 2 is his wife. The opposite party number 2 is the rented person's son, who is staying in the house of the petitioner.
Who is petitioner? Number 1?
Petitioner number 1 is the landlord, house owner.
Landlord.
House owner.
Okay.
My lord.
Petitioner number 2?
Is his wife,
Okay.
my lord.
And who is opposite party number 2?
Opposite party
Tenant.
number,
Tenant.
Okay.
my lord.
Dispute
Yes.
between landlord.
Landlord tenant. What happened? Tenant is not evicting.
My lord.
You want eviction.
My lord, quashing of FIR, total proceeding. It's because my lord kindly glance Annexure 3,
3.
which is settled between the opposite party number 2 and the petitioners.
So bring them at least the complaint will be there.
Se issue notice se jainki tanko ghoreta hochi, their house is at Bollagad and Noyagad. But at the time of filing the FIR, he was in the house of.
Why there are 2 FIRs then?
FIR, my petitioner number 1 FIR is Annexure 1. Petitioner number 2 counter FIR, which is.
What about counter FIR? You are not seeking quashing.
In counter FIR,
Where is that?
Annexure 2.
I understand. There are 2 FIR, then there should be 2 petitions.
My petitioner number 1 petition FIR is Annexure 1. And thereafter, when the petitioner number 1 and his wife, petitioner number 2, came to sustain bodily injury, thereafter they come to the Bidan ICPS police station.
I understand, madam. What I am saying is,
My lord.
if there are cross cases, there are
My
two
lord.
cases. You filed one case against them, they filed one case against you.
My lord.
You say that the parties have settled that dispute.
My
There
lord.
should be there should be two petitions
My
for
lord.
quashing both the cases.
My lord.
You filed one, whether the other side is filing a case or not. That's what I'm asking.
My lord, kindly glance Annex 3, page 27. Say you 27 day.
Compromise ଆପଣଙ୍କର ହେଇଗଲା
ଆଜ୍ଞା
ଯଦି ହେଇଗଲା ସେମାନେ ବି ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କ ଉପରେ କେସ୍ ଆପଣ ବି ଗୋଟେ ଫାଇଲ
ସେଇ କେସଟା ଆମେ କ୍ୱାସିଂ ପାଇଁ ଆସିଛୁ which is 831/2020 the ASC BDNSPS ମାନେ instead of quashing the FIR final form against the both the petitioner.
What you mean to say is the case which was filed by you against them has ended up in a final form.
My lord. I have also filed in the final form under Annexure 2, my lord.
You don't file anything, you don't say anything in the petition. And where have you said those things? Where have you said that those things?
My lord, in para. My lord. Parapur.
I simply issue notice, let us see.
My lord, page 4, para 4. Now the opposite party number 2 left the house of the petitioner. Then however, the petitioner taku kodi khojibo finding issue notice
କିଏ ଖୋଜିବ ତାହେଲେ କୋର୍ଟ ଖୋଜିବ ତାକୁ
no my lord, issue notice and stay the proceeding, my lord, till the appearance of the opposite party number 2, my lord.
He has already vacated your premises,
my lord.
Right on. Petitioner is seeking quashing of the petitioners are the landlord of opposite party number 2. Opposite party number 2. There was a dispute between the landlord and tenant, resulted in registration of 2 cross cases. Two cross cases, namely Bidana CPS case number 151 of 2020 and Bidana CPS case number 153 of 2020.
52.
The petitioners are accused in Bidana CPS case number 150. How many cases are registered, madam?
My lord, two cases are registered.
You just see the annexure. You see the prayer. You have said Bidana CPS case number 152 of 2020.
My lord.
And see the index which you have filed. There 151 of 2020, 153 of 2020. How many cases are there then?
There are 2 cases. My case is, my lord, the petition
Very
case is
difficult to
151.
understand.
152 is the opposite party who have filed against the petitioner.
Yeah.
152. 152. ତାଙ୍କ ଭିତରେ
ତାର ଉପରେ ଯୋଉ ଲେଖିଥିଲ 152 or 150 151 and 152
152 এটা Annex 2.
somewhere you are writing 52, somewhere writing 53. I don't know what if I
But I have to correct it. So 152.
152.
That a correction question.
152 of 2020. They are seeking quashing of the said FIR. Said FIR. And then counsel for the petition submits that the FIR registered by them against opposite party number 2. That is PS Bidana CPS case number 151 of 2020 has been resulted in filing a final closure report. Filing a closure report by the police. The tenant has also vacated the opposite party number 2 has also vacated the premises. He is relying upon a what is this Annex 3 compromise petition?
Compromise petition.
Would be police.
Compromise petition to the Bharapapta Adhikari Bidanasi police. Bidanasi IAC Bidanasi police station.
He is
By the
relying upon
opinion number 2.
Annex 3, a compromise petition submitted by the opposite party number 2 before Bidanasi PS, relying upon the change. He seeks the indulgence of the court for watching up the entire criminal proceeding. Issue notice to opposite party number 2, returnable on so and so. In the meantime, the proceeding arising out of Bidanasi PS case number. What investigation is going on or what in your case?
Already charge sheet is already submitted and the Honorable Court JMC 3 taking issue notice to the petitioner for appearance.
The proceeding arising out of Bidanasi PS case number 152 of 2020 pending in the court of
JMFC 3
pending in the court of JMFC 3
court.
Kotak. Is date, yes. You have not given the date of charge sheet also, nothing. And a petition are being filed. Next.
Item 92.
My Lord, Bidanasi PS case number 152, 151 in the.
I have done it. Oh, thank you. I have done it from. I saw it and did it.
Let's say pray for one pass over. Item 92.
Your job also I have done it.
Item 92, pray for one pass over.
Item 93.
May my submissions please, Your Lordship. In item 93, Your Lordship, this is a CRLNC which has been filed for quashing of a GR case bearing number 487 of 2014.
Yes.
Lordship, I need to establish the facts of this case before I place the Lordship. In this case, the complainant is the EPF department. EPF department in the year 2014 had registered a FIR against the petitioner. And in that FIR, it has been mentioned that the EPF dues of petitioner was the promoter and the director of Cosboard Industries Limited. And
you have not deposited PF dues.
PF dues
Yes.
for the period of March.
Therefore, you are being prosecuted.
Yes, Your Lordship. Pursuant to that, at Annex 3 series, if Your Lordship may peruse that, we have already the payment receipts of the EPF dues we have already annexed for that disputed period. And subsequently at Annex 4, Your Lordship, there is a letter which has been
All these things are compoundable offences.
Lordship, and another issue, another aspect, Your Lordship.
Sir, all these things are compoundable offences.
Lordship.
You would go and tell that court that I have already deposited.
Lordship,
And
that
it will be compounded.
has already been brought on record. In fact, Your Lordship, during the course of the pendency of proceedings, the company which was held to be liable for non-payment of dues, it has gone into insolvency proceedings as under IBC, and a successful resolution applicant has taken over the operations of the company. So the current petitioner at this point, he is in no way connected to the company at whatsoever.
Have you moved this application before the court below?
Lordship,
where is that? Show me.
Lordship, the letter at Annex 4 has been given by the commissioner, the regional PF commissioner to the learned JMFC at Annex 4, Your Lordship, page 67.
Yes.
In page 67, Your Lordship, they have also mentioned that the employee share of provident fund dues of employees amounting to rupees 15,14,533. It has been deposited and the copy of that has been enclosed as per the Annex 4 at page number 68 and 69.
Yes.
All of these documents are on record with the.
I am asking something very pertinent. Have you moved application before the trial court for compounding of the offence?
Lordship, I'll have to check because we'll be appearing on a change of wakalatnama in the lower court.
Because these offences are compoundable offences. Under section 320 of
320,
CRPC, you
yes,
can move
Lord.
application and it will be compounded. If in a compoundable offence, why 482 will be exercised?
Lordship,
where there is no, it's not compoundable, then 482. If it is compoundable, you move an application. Have you moved such application?
I'll have to check with that. Your
That's
Lordship.
what I'm asking. Whether you moved, if you have not moved, tell me, I'll give liberty and move the application.
Earlier, your lordship passed the order.
Where is that?
Yes, your lordship, this matter was
Base
73.
73, okay.
At 72 it starts.
Operative portion is at
Okay.
73.
Yes.
Subject to petitioner appearing before the court below and avail remedy as per law.
See, I have done it.
Lordship,
I have cancelled. I will extend the this thing time.
No, Lordship, after that, we had also secured an anticipatory bail before the.
Then why are you not moving application? I have given it the indulgence already. Move application.
Lordship may keep this application pending, and if I may be allowed to seek remedy before and pursuant to that, if your lordship may.
I'll put it on 19th. You just simply tell me whether you moved application or not. If you have moved application under 320, I'll give you that liberty, and if such application is moved, the trial court will decide it.
As per my.
There is no threat. You will not be arrested.
No,
I have given that indulgence to you.
Lordship.
Then what is the big deal? Why don't you move the application?
Lordship, as per my instructions, the case before the learned trial court is on 21st of December. So if your lordship may keep this application after the vacation, I may be able to.
Rather, you do one thing. If it is there in 21st, you move an application there.
Lordship.
And if it is allowed, then it will be infructuous. You tell me. I'll dispose it up.
Yes,
If it's not allowed, then something. I'll simply adjourn it to the first week. Okay?
Much obliged. That is what I'm saying, your lordship.
First week. Second week of the
Yes, sir.
second week of January.
Second week of January.
On 21st, you move application.
Yes, your lordship.
For compounding.
Yes,
and disclose that this matter is pending. I'll withdraw it.
Okay.
Disclose that.
Yes,
Don't conceal it.
No, your lordship. I'll
Don't conceal. In one paragraph, you write that the matter is, although you approach the High Court by filing this petition, but since the offences are compoundable, we are moving the application. You move it. If it is allowed, then it will be infructuous. I'll dispose it up. Okay.
Much
okay.
Item 94.
Yes.
May I please, madam? This is a bench of case, madam.
Yes.
Bail was allowed on 4317. Invitation was issued on 29/8/24.
Yes.
That order was not annexed because copy
500.
was not
Okay.
available. So I have filed the copy for dispensing with the filing of certificate copy. I have annexed.
So that I allowed for the reason stated in the application and for the yes. Okay.
29/8/24.
500. Yes. Yes.
Item 95.
95, my lord. This is a peculiar case, my lord. This is a vigilance case, my lord. Cognizance order is under challenge. No work was pending with the petitioner, and the sanctioning authority who has sanctioned, he is not the sanctioning authority. The petitioner was working as DECC, and the sanctioning authority was the collector. But the district inspector has granted the sanction order. So that is under challenge. My friend take.
Yes. Sanction order. Is not competent authority. Okay. On the ground that the petitioner, petitioner is seeking, petitioner is challenging the order dated 21/4/2014. 14 cognizance is taken. Now you are coming. What is the stage now?
Cognizance order 20/15.
15. Yes. Sanction order is 20. Now what is the stage? What is the stage now?
Some witness, sir.
At this stage you are coming for
The sanctioning authority has also examined. They have stated that I am not the sanction.
Then why should I interfere at this stage? I can't scuttle the trial at this stage. You should have come at that stage.
I may, but 1 minute, madam. 1 minute.
Sanction authority is also examined. Now you are challenging sanction.
Madam, one thing.
2014 sanction is given. You allowed the trial to proceed for such a long. I'll expedite it if you want. Nothing else can be done.
One thing, madam.
I can't scuttle the trial.
Madam, the sanctioning authority has already told that I am not a sanctioning authority.
Can I appreciate the evidence at this stage?
That is.
Or can I ignore the evidence at this stage?
No.
Whatever wrong, right, whatever has come. That has to be examined by the trial court only.
Madam, 1 minute, madam. Madam, kindly have a glance only. Madam, have observed that my submission and the sanctioning authority who has been examined.
When the trial is proceeding at an expected pace, a 482 court giving an opinion at this stage is not permissible. You should have come in the right time. It's a case of latches on your part. Complete latches. What I can do is I can just expedite the.
Madam, observe one thing, madam. the statement of the action.
Then I have to appreciate the evidence then. Can I do it? I can't do it. That's the problem. I can't appreciate the evidence. He might have said in your favor. Which part you are relying upon?
Cross-examination list. I am not the collector is the sanctioning authority.
He says collector is, but I have given it.
Observing that you are.
No, I can't touch this evidence. I can't touch this evidence.
If I say got a line observation, that is sufficient.
I may record your statement, but I can't.
That is sufficient my purpose.
I'll not appreciate the evidence.
That is sufficient. While I will keep it and while dictating. Then
I'll just record your statement, that's all. But I'll say that I'll not record. Petitioner is seeking passing of the cognizance of the order dated 28/2015 passed by learned. Where is that? 30, na? 30. Passed by learned special judge Vigilance Cuttack, whereby cognizance of offences punishable under section 13(1)(d), 13(2), or read with 7. PC Act has been taken against the petitioner. Mr. Pondal and counsel for the petitioner is challenging the state cognizance order on the ground that the sanction has been recorded by an incompetent authority while its office order dated 29/12/2020, 2014. He has the trial in the present case is proceeding at the expected pace, and witnesses have already been examined. He has pointed out the evidence of testimony of the sanctioning authority recorded on 19/6/2018, being PW10. He submits that in the cross-examination, the sanction authority has specifically admitted that the district collector is indeed is the sanctioning authority. However, he is sanctioning authority. On the basis of the said statement, made by the authority who has accorded sanctions for prosecution of the Ponda submits that the entire proceeding is vitiated due to the according of sanction by an incompetent authority. Hence, he seeks indulgence of this court for seeking copy of the cognizance order dated 28/2015. I am not inclined to entertain this petition at this stage, at the belated stage, as the trial has already been proceeded. The evidence of the prosecution has already been recorded. No problem. However, recorded. Hence, the petition is disposed of. However, liberty is granted to the petitioner to raise all these points before the court below. If such issues are taken, the same is expected to be dealt with in accordance with law. Yes.
But I mean, but one line more in cross-section that is there. BRCC has no role for the instead of CRC.
See, these kind of orders are very dangerous. I can't appreciate the evidence. I've just recorded your statement because you said that. That's all.
One line more. While hearing the learned specials are dated.
I have said that it is expected that whatever point you will take, it will be dealt with. Yes.
Okay. Item 96. 96, Lordship, petitioners challenge the order of cognizance, Lordship. So continue under section 341, 294, 323, 506, 34 IPC.
Yes.
Lordship, in this case, compromise has already been in the final stage, Lordship, between the parties, Lordship. So,
final stage.
Lordship, I pray for next week.
Local 323 and all. Petitioner is seeking quashing of the order dated 14/8/2023 and passed by Special Court under AC and ST bracket POA Act, Cuttack in city case number 86 of 2023, whereby the court below has taken cognizance of offences punishable under section 326. Counsel for the petitioner submits that the parties have already arrived at a settlement.
It's a final stage, almost.
Or exploring it.
No, as per my instruction, it's already in the.
Already arrived at a settlement and working out on the terms of settlement. Hence, he seeks indulgence of this court for quashing of the proceeding on the ground of a settlement. Issue notice to opposite party number 2, written in ground. In the meantime, petitioner may move an application seeking adjournment before the court below, owing to the fact that the matter is sub judice for this court. Yes. Second week.
Item 97.
To review 31D of the PC Act.
Yes, sir.
In this case, there are 9 numbers of accused. One of Sri Ramachandra Jain has already been before my lords, and your lordship is passed on. Similar order kindly pass. Only he is the Amin, he is the customer.
Yes.
Difference is.
Who are you?
I am Amin.
You are the Tahsildar.
Amin, huh?
You are the Tahsildar.
For Tahsildar, I pass this order.
ये तो अमित
Tahsildar Amin को pass होगा. नहीं, what is the ultimate order?
ultimate है ना से आयु पकड़े
हाँ, ठीक. Amin करो, Tahsildar लिख दो.
Item 98.
And I would paragraph the Tahsildar accused before. Second accused Tahsildar before you had approved this court by filing from this was upon service. The petitioner seeks the disposal of the present in the same terms. It's happened.
98.
My application. Appellant is convicted for the offence, my lord, 13 for the PC Act and sentenced to undergo RI for 3 years, my lord. And fine of rupees 5,000, AD undergo RI for 6 months.
Okay.
And for the offence.
409, 4 years.
4 years, my lord.
And 13 to 3 years. He is in custody.
Custody bail granted, huh? Bail granted, subject to whatever, and realization. Yes, yes. TCR called for and same. Yes, next.
Item 99.
Listed after receipt of the TCR.
Oh, so standard order.
Because all the matters are being listed from time
Standard
to
order release letter for final disposal after receiving of TCR. What is so yes.
time. Appearance may be noted.
May I please?
Yes, sir.
My lord, here the petitioner has challenged that order passed by the Lord and Special Judge Vigilance Cuttack Lordships. Order dated 3/4. Your lordship may kindly visualize one. Here is a proposition.
Pass over is asking.
ଗୋଟେ ଜିନିଷ କାଳେ ପାସ୍ ଓଭର ନ ହେଇକି ଆଉ ଦିନକୁ ଯିବ ଏଇ ଯୋଉ କେସଟା ଯୋଉଟା କି ଡିପାର୍ଟମେଣ୍ଟ ପ୍ରୋସିଡିଂ ରେ ଏକ୍ସୋନରେସନ ହେଇଛି
ସେଟା ସେ ମ୍ୟାଟର ଗୁଡାକ ପେଣ୍ଡିଂ ଅଛି.
ସେଇଟା ହଉଛି କଥା ସେ କଥାରେ ସେଇଟା 3-4 ଥର କୁହାଗଲାଣି ଆଜି ଆସିଛି.
No, I have already heard that matter. I have reserved the judgment.
So the same thing would be done here. Same thing, same issue.
I will not decide fact wise. I'll lay down the law on that basis.
Yes,
This
that
thing.
that Pani. Minakatan Pani. That is 2022 OCR.
That much water is already flown under the breeze after Minakatan.
Yes.
After Minakatan is no more there.
Four judgments of full bench decisions, and also Minakatan, and also 3 judgments of Honorable Supreme. I would rely on.
No, everything they have argued at a very extensive.
So you lordship may
If you want to argue, I'll keep it after case.
You lordship may do one thing.
I will reserve the judgment along with that. You give written note.
No. You lordship may do one thing. You lordship may keep it as adjourning this case to some other day. You lordship may pronounce that judgment Then it will be covered by that.
ठीक.
And
Second week.
then
Second week.
tomorrow your lordships, that date is posted for telling
The
of.
same arrangement is there.
Your lordship may pass that.
Yes, the same arrangement. Yes,
Second week of January.
yes.
Item 100.
Or your lordship may keep it, I will give the written note of argument and the same arrangement. I will give the written note of argument.
No, not both. Not both. Either I reserve judgment, then let the trial court proceed. I'll keep it. Better wait. Better wait.
Right.
Item 100.
100 Belgium matrimonial order dated 20/5/2013 at page 15.
Yes. NBW 2013.
Mile. 5 packet persons.
Which police? Which this thing?
457 3.
Glance at page 13 and 14.
Korapur. Kotangi. Yes. I'll go.
Lordship, the bail was granted for only 2 people, but the present petition, there are 5 persons. That is the only thing.
Bail granted to whom?
Bail was granted to all the persons. This is that has not been reflected in the order sheet, but
I'll record that bail was granted,
Yes, sir.
but
Certified copy of the charge sheet.
then counsel for the petition submits that all the petitions were on bail. However, due to their default in appearance before court, NBW has been issued by the order dated so and so. Okay, you district court, Bar Association district court. Everybody has to pay 500.
problem.
Item 101.
Yeah, previous matters. Earlier the petition were on bail matters.
NBW issued on 16/5/19.
100. 2013, na? The earlier one to 1000.
Yes, sir.
1000.
1,000.
Each. 1000 each. Yes. Yes.
Item 102.
Well, yeah, then the petition was in.
101. 102 can't do. 101.
101. Yes, sorry, 100. Yes.
Matters.
Yes.
That's mostly PS 26 matters.
You tell me date.
Yes.
This is NBW Quashing?
Yes, sir.
Yes,
You tell me the date.
NBW was issued on 16/5/19. Subsequently, was released on interim bail on 3/4/19.
And on the first instance, NBW has been issued, matters.
NBW issued on which date?
Matters.
16/5/19.
Yes, matters.
You retain something else here.
16/5/2019 matters.
In the prayer, he's written something. Anyway, 16/5 लिख दिया. 16/5 इधर होनी चाहिए. 1000. 1000. 1000. ठीक है. 1000 each. 3 of you are there. 500 each करो यार. 500 each करो. Jajpur district ना. FIR Jajpur.
Yes, matters.
Yes, Jajpur district court. ठीक है.
Matters.
Yes.
First, I have to deposit here, matters.
Huh? Next 102.
Yes, 102.
Local bar. You give local bar.
Item 102.
Here the present petition was on anticipatory bail. Madam may see the order. It has also been reflected that he was on anticipatory bail.
Anticipatory bail.
and also released on
NBW issued on 20/2/2024. 500. Yes.
Item 103.
My lord, in this case, NBW has issued 17/7/2024, my lord.
Yes.
My lord.
Bail.
9/8/23.
9/8/20.
23. 500. Yes.
Item 104.
Yeah, please, lordship. NBW order issued, my lord. At by
9 to
10.
10.
My lord.
Wow. Where were you? How many of you were there? How many of you come? 1. What about the other people?
Other
Trial
people,
is
my lord.
splitted or what?
My lord.
2000 to the local bar. This is Bhubaneswar. 2000. Yes.
Item 105.
It's a case, my lord, where the landed court has issued NBW based on a prayer of the IO on the same day of taking cognizance, my lord. Against which I have
White order dated 6/8/6. Sir, 8/5/2024, the Special Judge Board had taken cognizance of offences punishable under section 20 bracket B1 B2 C of NDPS against the petitioner and also issued NBW against them. You are on bail.
No.
The thing. Yes. 1,000.
Directed to surrender, release on bail.
Yes. Time I'm giving
Fine.
that.
At 106.
106, my lord, this is a Belgium matter, my lords. Earlier petitioners were on bail, my lords, and NBW is issued, my lords, 3/4/2024, my lords, and petition number 1 arrested and released on bail, my lords.
Petition number 1.
1 arrested and released on bail.
So this petition is infructuous in petition number 1.
Matters.
Right, petition number pertains to the order dated 3/4/2024, whereby the NBW against the petitioners have been issued by the court of so and so, Nyadhikari Grammanyal, Puri. The petitioner number 1 has been arrested and released on bail. So therefore, the petition is infructuous insofar as petition 1 is concerned. The applicant petition number 2, 3 will appear once that taken and pay 500 each. Yes.
At 107.
107, my lords, NBW issued petitioners was absconder, my lords. NBW issued, my lords, 2/9/2023, my lords. Absconder, my lords, petitioners.
Three of you.
3 accused persons.
They are absconder, 1,000 each go.
No, not in bail, my lords. Absconder, my lords.
Which Grammanyal? Where is it? Additional session says?
No, এটা additional session judge কামাখ্যানগর লেখা ହେଇଛି কিন্তু কেস টা পড়েছি অদর কো আকিউজ কর ট্রায়াল আরম্ভ হইছি কিন্তু দিস কেস ওয়াজ আর্জুন এসটিজিএম কামাখ্যানগর মাইনরস অর্ডার সেটমেন্ট
ঠিক yes
at 108
my lords petitioners was on bail, my lords, and NBW issued 24/10/2024, my lords.
24.
Yes.
Bail date you have?
My lords, the order sheet reflected, my lords, accused persons on bail are absent but allowed to be represented. Bail is not there, but bail.
Okay, 500. Yes.
Obliged, my lords.
At 109.
May I please, Lordship, the NBW is issued on dated 27/9/2024, and I was on bail since 22/6/2020.
2020.
2022.
Okay, 500.
But the NBW is issued on dated 27/9/2024.
Okay, 500. Yes.
110.
What do you want? You want to say anything? I've quashed it.
Lordship, I have a submission. Please kindly grant it to allow the 500 on local bar.
Okay, local. Yes.
For-
Local court. You local court में click कर दो. Yes. 110.
NPW issue of 23/11/2021 on the prayer of the IO before the charge sheet was filed.
Before the charge sheet was filed. ठीक है? 500. Yes.
So he was not on bail.
I understand. On the request of IU. Yes.
111.
Belgium Metro, my lord, petitioner was on bail since 2013. NBW issued 12/12/2020.
Do you have a date of bail? No. 2010 on bail कर दियो. 12/12/2022. 1000. बरमपुर गंजाम बार. ठीक है? Yes.
Local bar, man.
112.
This is the Belgium Matrimonial NBW issued on 31/7/2014, and the present petitioner was released on bail by the National Court on 19/11/2019 in BLPL number 7321 of 19 mile.
Okay, 500. Yes. Yes.
113.
NBW was issued 23/10/2024.
Bail was submitted on 25/7/2024.
Okay, man.
500. Yes. Yes.
114.
Yeah, my lord, the petition from my lord is a lady, Belgium, and it was passed on 29/7/2009.
2009.
Again. Lady
on bail.
Admitted. Madam, I see the record. He was on bail granted by the National Court in BLAPL number 15. Yes, 15.
Banapur Bar Association. They have a bar association?
Yes.
Pay 2000. Yes. 2000 Banapur Bar Association.
At 115.
Yeah, my lord, NBW was issued on 31st May 22 on the prayer of the IO, my lord. That is before filing of the charge sheet. And this person was not on bail, my lord. He has been shown subsequently in the charge sheet. He has been shown as abscond.
Absconder on the request of IO, NBW issued 500. Yes.
116.
Bolangir Bar.
Petitioner is a lady. Warrant was issued on 19/7/2024, and he was on bail on 27/4/16.
16.
Yes. He's a
100,
lady.
116. 116. 116.
My lord, she was unmarried at that point. Now she has married. Thereafter, she could not know all these things.
116. Okay. 1000. Yes. Yes.
117.
Annual issued on the 2nd December 24, madam.
Mhm.
Was on bail on the 23 September 23.
Okay. 500. Yes.
118.
18,
my lord.
Huh?
It's page of matter.
NDPS was issued on 3/1/22.
I need some time because today morning I have get.
He was on bail, sir.
He was on bail.
Maybe. So other aspects are there.
No.
No, what is this? What are they?
He was on bail, my lord.
Huh?
Telephonic instruction what I have obtained. I need the written instruction. Involving more than 300 crores of rupees fraud, and he
That
closed
is an
all his
easy case.
establishment and left the country. And a lookout circular has also been issued by the ED.
Now he want to appear in the court.
No,
He is in custody in the ED case.
Hmm.
Now an objection was raised. He never knew that this because
He is in custody in some other case.
in another case, my lords. What had happened, my lords? His son stays in Dubai. So he goes off and on. After COVID, he was staying with his son. So whatever he had already got bail by order dated 17/1/2017 at page 48, my lords. Bail was granted to him. Now, my lords, once bail was granted to him, thereafter, my lords, he thought that as a natural course it would go on. And later on, my lords,
He once he went to Dubai, didn't turn up.
No. Thereafter, he has come back. If it was
he has given, that is also found false.
No,
So what now he wants to participate in the proceeding?
and he is in custody, it's not that he will flee away somewhere. Only thing is if he gets bail, my lords.
He has been arrested and he is in custody by the ED.
Hmm.
So now I have to take instruction. That affidavit is filed by his son. That is another aspect.
Yes.
So whether and the case is split up at because of the non-appearance.
Reject it. What will happen? Suppose I will reject it.
I don't want
then-
rejection. I don't want rejection.
Then I will bound him to appear.
Also not open my mouth. The thing is that I have to take instruction on this point because
Or just for some other reason he wants. Some other reason. Day after, huh? Day after. For some other reason, you must understand that.
I have a,
Day after.
I have a prayer.
My lord,
my-
may I mention?
I have a prayer, my lord.
Yes, sir.
143.
Yes.
That may be taken up after holidays because my lord, 3-4 matters are clubbed together. Where I have to appear in those colors.
On request of yes. And rest of the matter I'll take up. I'll just come.
My lord, may I
He's appearing on behalf of the informant journals.
Okay. Call password. Yes.
Item 60, password item.
16, 16.
Yes, sir.
Huh?
60. May I please your lordship? In the
Yes.
last occasion, your lordship has taken a view that the OPID matters are already pending for the Supreme Court. So that's why the petitioner is already on bail. But petitioner could not able to comply the order
because the cash security was 5 lakh and some 2 lakh, 3 lakh, it has been modified twice also. Ultimately, that person is not able to deposit that. In the meantime, he has already undergone imprisonment more than 7 years plus. The trial is not completed. Even though.
Where is that condition?
Millard?
Condition, bail condition.
Millard, I am just coming to the conditions. One by one. Millard, 5 cases are there. So all the 5 cases. And
I told you to get instruction. In 5 cases, he is already there in custody about 7 years.
More than 7.
See, he is not able to comply the bail condition. So it has to be relaxed. He has to be granted bail.
No, bail has been granted by this alone.
Bail has been granted, but the conditions are onerous. Very fact that he is not able to comply itself shows that it is onerous.
But
Why should he be there in jail?
But the said order has been modified twice.
Let it be modified many times.
Alternate remedy is available to him.
What is the remedy?
That higher offer. So 482 jurisdiction is limited. Furthermore, Millard.
480 to meet the ends of justice, anything can be done.
This
is a fit case according to me because he simply, you see how many times he has gone to the High Court for modification. And time and again, whenever he goes, it is modified. Earlier it was 7 lakhs or something.
5 lakhs, then
5 lakhs, 2 lakhs like that. Even then, after so many modifications, he is not able to pay the money. He is there in the jail for 7 years.
7 years or more.
How many years you will keep him? And you will ask him to go to Supreme Court now.
And otherwise, that is the otherwise
maximum punishment is OPID.
Application is not maintainable because of he is challenging.
Don't go by the nitty-gritty. In this, in the criminal jurisprudence, liberty supersedes everything. Liberty supersedes everything. Forget about the technicality.
But
I told you, therefore, I'll let him go on bail.
Millard, liberty in economic offense is very limited.
No, Millard, that
is the law.
Already 10 years.
What is the sentence? 10 years total.
10 years total.
Even if you
OPID,
convict him. And how will you deal with 336 capital A?
Correct.
436 capital A?
He has applied a bail application under section 436A. That was rejected. So, forum is to file another bail application before this honorable court. Not in 482.
No.
Because of the an order is existing. In 482 order, a coordinated bench order can.
We have filed a special IA for 5 cases. And only prayer is for waiver of the security, Millard. 5 IA have been filed, Millard. First IA is 3338 by 2024. Again, another IA is 33343 by 24. And another IA is 333.
What are you asking here?
So only waiver of the conditions of cash security. Complete waiver. So that he can able to be released from your lordship.
In all the cases, you are in custody for 7 years.
For 7 years. Millard, first arrested on.
I told you to give a chart. You give me a chart. Give me a chart.
The chart, everything I have written.
The 436A, right is not absolute. The court is find out whether.
Give it. What is this? Nobody can understand. You some doodle some in some paper. What is this?
Then it's just mismanaged.
I don't understand how you deal with the court proceedings. You written something and
then Beloved, I have already given in.
And you don't want that your client should get relief.
No.
Immediately after first week. I told you, you give in which case when you were taken into custody.
That is already stated in the petition, Millard. All petitions I have stated.
You have filed 5-6 petitions.
5 petitions.
Therefore, I said that in one place you give it. You want me to do exercise for you.
Millard, I thought, Millard.
Whatever you thought, I told you that.
No, Millard, everything I have stated in the petition, Millard, and that is in stated in your.
And why are you arguing? You simply say that I have said everything in the petition, read it and pass the order. I'll do that.
No, Millard.
That's what you are trying to tell me.
Millard, that is not the intention. That is not the intention. Millard, that is not the intention, Millard.
In which case you were taken into custody when? I want to know. And 6 cases you have filed.
Millard, in the FIR filed on 21/7/2017, when he was taken to custodian, 13/1.
That is which case?
That's Millard. That is.
How will I coordinate?
IA number 3334, Millard.
In which CRLMC?
CRLMC is.
That is why I am saying. Which CRLMC? Which IA? Which FIR?
2197/24, Millard.
Don't understand. 24th. Please read out 24th. 23rd, you write. 23rd. At least you prepare a chart. You have filed 7 CRLMC, 7 CRLMC. 5 CRLMC. Which CRLMC, which IA?
Miller.
Which is the FIR?
Miller.
And when you have taken into custody. And
Miller.
what is the amount
I will
directed
give
to
you a
it?
tabular chart.
Give that chart so that I can understand it.
Miller, tabular chart I will. Definitely.
And he is taking an objection of 482 proceeding. That objection will take care of.
Miller.
Do it on the 23rd. I would have disposed of right now. All the five.
Miller, I thought everything I have stated in the petition, so that.
Yes. Next.
Item 62.
Yes, 62. Yes.
Yes, Your Lord. The informed order of High Annexure 1 series.
Yes.
Running page 14 to 27 has been challenged before this Honorable Court, in which the court will completely to exercise the regional power, directing the opposite party members, directing the ADCC from adjournment in order to enforce the order passed by High Annexure 2. Please kindly see the page at page number 26 and 27.
26.
Yes,
okay.
Running page 26 and 27.
Yes.
Paragraph number 6 is and paragraph number 7. Kindly reading.
Here.
Under section 155 subsection 6 of a CRPC, the magistrate is authorized to issue an order declaring the party to be entitled to possession of the land until evicted therefrom in due course of law. The magistrate does not purport to decide a party's right title or right to possession of the land, but expressly reserves that question to be decided in the course of law. The foundation of the jurisdiction is on apprehension of breach of peace, and with that object, he makes a temporary law, irrespective of the right of the parties, which will have to be agitated and disposed of in the manner provided by law. The life of the order is coterminous with the passing of a decree by a civil court, and the moment of the civil court passed an order of eviction, it displaces the order of the criminal court. When the civil court is sitting over the matter, the enforcer of the order back in the year 1997 doesn't arrive. This is the order. And then what the court below has committed error, the Lord Executive Magistrate has rightly declined to enforce the order passed under section 145(6).
Because there was a decree.
Sir?
Because there was a decree. Yes.
Decree was passed by the Executive Magistrate Venezuela in respect of the particular land in favor of the petitioner, and by confirming the right title interest to whatever, to the extent of subsection 601.
Yes.
Yes. In favor of the petitioner, and accordingly the petitioner continued their position, but all in a sudden with an unexpected manner by the year 2022, that is on 29/5/2022 at about 4:30 AM onwards, the first party member and his miscreant and antisocial element up to approximately 50 to 100 persons issued into the suit property of the first petitioner and made a threat and menace in order to grab the suit and damage everything which has already been narrated, everything by Annexure 3, by Annexure 4.
So what are you seeking?
Sir?
Let me understand. What are you seeking? Why are you giving this entire story? What relief you want from this proceeding?
The court below has failed to comply with its statutory duty by directing the ADCP Bhubaneswar in order to enforce its order passed in CMC number 403 of 1995, which was decided 9/6/1997. Please kindly see the Annexure 2 series. Annexure 2. Annexure 2 as per effective portion finding and order from running page 49 to 50. Finding that
you are the first party.
Again, I am the first party before the.
Who is the second party?
I am the second party.
Who is first party?
Orissa Constructs Techno Engineering, the first party.
But you have not even included them in the petition.
No, since the there is no question there, since the judge magistrate has already failed it, and instead of complying its order. Then
You
the
don't
international order
understand.
has been
See,
challenged.
this is a proceeding arising out of a 145 CRPC this thing. And there is first party, second party. Okay, it is between you. And if you are challenging some order arising out of that proceeding, it is necessary that you should implead him.
No, order has been flouted by the judge magistrate. And that order has been challenged before the.
You have to make him as a party.
Apart from that, your lordship,
Let then the I file the implead the opposite party.
6 to 6 leave of this court to implead the implead the second party, na? Second party, sorry, second party. First party. As opposite party number 2 sounds. I understood it. There is a civil decree, nothing is petition. Yes. Next.
Item 64.
I'll give a date. Yes. Implead first. First implead.
Item 64.
Crops up out of a political dispute when there was a proposal for no confidence motion. And peculiarity of the case is opposite party number 2 is my husband, petitioner is the wife. Wife, my lord, was in a different party, husband was in a different party. So no confidence motion was moved against the chairman. So wife was taken by her supporters to a different place. In between, no confidence motion has been over. I think that has been must have been subsided.
What are the offenses then?
Kidnapping.
Other offenses are there.
25,
27,
kidnapping along with that.
25 arms act, 331.
Suppose.
And you have kidnapped your wife's supporter.
My wife, present petitioner, is the victim.
Okay.
She has been kidnapped by, say, 1 to 7 persons. 7 persons of her group.
What you want now?
That the case against the accused person be quashed. But I don't think investigation must have continued by this time.
You want that the proceeding should be dropped against your husband?
No, my husband is the informant. Husband is the informant, I am the victim. Victim has filed the case.
Victim has filed.
Okay. I understand.
My husband.
I'll issue notice being
let her.
Are you staying together or?
Yes, at present we are staying together.
Same party or change the party or after this you might have changed the party also.
Political game melody is nasty game.
Change allegiance.
He has to. Because you want to stay in the house, then you have to. Yes, issue notice.
Only that, but no stay for that.
Second week record.
Because it is over, I have not been instructed.
Just take it up whether you have. They might have. They may file closer.
By the time this dispute was there, so her presence was required, for which husband had filed this case. I don't know. I have heard that in Khondpada, this NSC chapter with regards to no confidence has already been moved.
Dropped.
No, moved, and new chairman has come. But about the present case, they have not contacted us.
Okay. Next.
Item 77.
Tomorrow it will go after vacation. After vacation it will go.
Today did not get some prior both of the judgment matter.
Okay, tomorrow. Okay, tomorrow. Please it tomorrow. Yes.
Item 83.
My lord, may I please? My lord, informant.
Now you
informant, complainant before the London JMFC 1cc 224/2015 alleging therein that he is the registered owner of said vehicle summons.
What are you seeking in this petition?
My lord,
what are you seeking in this petition?
My lord, truck टा रही पड़ी पड़िका खाली नष्ट हम से 2015 केस एत वर्ष हो गलानी लास्टली ऑर्डर The trial is expected to be concluded soon. However, I am of the opinion that.
Where are you reading?
My lord?
Where are you reading?
My lord, page number 41.
Yes.
ସେଇ ଗୋଟାକଟା ଅର୍ଡର କରିଛନ୍ତି ଆମର ସ୍ପିଡ ଇଏ ହେଇଗଲା 41 ପେଜ ନମ୍ବର 41 ଲାଷ୍ଟ 1 2 3 4 ଲାଇନ୍
So you are the informant and your vehicle is at your vehicle, you are the owner of the vehicle.
Yearly disposal for the
Petitioner is
sorry ସେତେବେଳେ
petitioner is the informant in the NPS case number so PS case number so. What is the stage now?
now trial
stage my lord ସାକ୍ଷୀ କିଛି ଆରମ୍ଭ ହେଇନି ଚାର୍ଜସିଟ୍ already file
how many witnesses are there?
How many witnesses, my lord? 20 witnesses.
How many total witnesses?
20 witnesses. 22 witnesses.
22 witnesses. Charge has been framed.
My,
yes.
Yes.
Page 26, 27.
Which is that vehicle?
Vehicle truck.
My lord, truck number OR04H 5154
is the vehicle. Truck bearing number OR04H 5152 54 and has is entangled in the present case. Due to pendency of the trial, the vehicle is not being released to him, and his application under 457 CRPC has been rejected. In the present proceeding, he is seeking the expeditious disposal of the trial. Expeditious disposal of the trial. Free, fair, and free trial is a constitutional amendment. Therefore, the claims made by the petitioner is innocent and deserves merit. Accordingly, the trial court is directed to do well to see that the trial of the case is expeditiously disposed of. The trial of the case is disposed of as expeditiously as possible. This observation petition. Yes. Yes. Within I can't say. You don't know charge is framed or not. 22 witnesses are there. Yes.
4 months.
88.
But please, but here in this case, Lord, I have challenged the very initiation of criminal proceeding against me. If you also please see Annex 1 is the impugned FIR at page 14. Now, Lord, 7 persons were added as an accused person in the FIR. The allegation made by the informant was that, and then included a section 376 in the FIR, Lord. The allegation was that these accused persons were the office bearers of one company located at Gopalpur, Ganjam, and the informant was allegedly working as an employee in that company. These accused persons showed some undue favor to that informant and subsequently tried to physically assault her, and then the allegation of rape was there. That investigation, which police
354A, 354.
Yes, charge sheet was submitted on 354A, and the order of cognizance also passed only against lots of. Now, in the meanwhile, the internal complaints committee challenging the entire proceeding settled. Husband and wife,
they are staying together.
Testimony and a blessed 2 girl child.
Affidavit. First figure, second figure. Yes.
120.
Yes. For that case, my lord, 100, my lord. No. 1 kg, 104 grams of codeine, my lord. 1 kg from the total bottle of 100. 1 kg, 104 grams.
5,520 bottles.
Bottles 5,520. Podium, huh? My lord. I am in Sabaito, my lord. So far, my
20 and 22 are the same, my lord. Some co-accused persons are there. Last time I was kind enough to direct us to examine.
Same FIR co-accused.
Yes, same co-accused.
Recovery same.
Some persons were arrested from the spot. So far, the item 22 is so far the item 20 is concerned. 120 is concerned. He has not been arrested from the spot.
Now, who is arrested from the spot?
So, one Pinky Meher, my lord.
Pinky Meher and 6 others, my lord.
In this, my lord, batch of cases, my lord, 2 persons arrested in the spot, my lord.
Pinky Meher, 6 persons. My lord, I have read out one name. No, who are 7 persons, my lord, apprehended from the spot. Jone ki koile jani karibo, otherwise adjourn kar debe power vacation pore.
7 persons have been arrested on the spot, my lord.
Yes.
And while they were interrogated, Pinky Meher stated that there is a racket.
From spot, 7% were
named, my lord. On their possession, this commercial quantity of codeine phosphate has been seized, my lord.
All the 7%.
7%.
Yes.
So out of that, my lord, Pinky Meher and this Rohit Agarwal. Today their application is there. And others, they have been, your lordship has directed me to accept the confessional statement. What others is, other material there. That on the basis of the confessional statement of that Pinky Meher, they have been implicated. And so
from the spot, how many people you have
7
apprehended?
7 persons.
Apprehended.
7.
All 7%, including Pinky.
Pinky, including.
Okay. And these Rohit is also was there in out of 7.
Out of 7, which is
Rohit. And what about Roshan?
Roshan was not.
Rohan. Rohan was not apprehended
No,
from the spot.
So may I suggest one thing, my lord? So far the
Why are you not making me clear? Rohan was there or not? When you have you apprehended from the spot?
Rohan was not there.
And what about Rajesh Nag?
Rajesh was not there.
Rajesh was not there. What is Ravi? Not there.
Ravi is also not there.
Not there. And what about Dusmant? No, Ravi. Itna, yeah? Ravi. Then the only Rohit was there from the spot. So then conscious possession can be attributed to him.
Attributed to
Rohit.
And 120 to Pinky. How others so again confessional. I 17 meter aschi total.
17 কোটি আছে
total মানে the accused persons are
with who take আসছে
এটা কেতরা আসছে ভাইয়া মো পাখরে রোহন 1 এটা 2 এটা 3 4 আসছে
ଆଉ ତାପରେ 122 ରେ ଦିଟା ଅଛି
ଶିବା 122 ଟା ବିଷୟ
Sonu Tandi
ତାଙ୍କର ଦିଟା ଅଛି
and Pinky Meher
ର ଆଜ୍ଞା ସେ conscious position.
Yes.
Pinky and Rohit Agarwal rejected.
Exactly. May I pray?
Pinky
yes, madam. So far, Pinky.
Before I change my mind,
I am with the same view, madam. I am also accepted.
Conscious position.
Because the fact that Pinky and one Subhadra, 2 persons have filed the application, but may permit to withdraw so far Pinky is concerned. So that the other person who has not been arrested from the spot, her application can be taken.
When all these people were apprehended?
Yes. Time to time. So far, this
chart, can you give me a chart? Shall I put it day after? Prepare a chart so that easily I can give.
All the persons were arrested on the same day, madam.
Same day.
All the persons were arrested from the same day.
No, not from the spot means must be arrested later on. Don't see that.
See, same gote din dhara padi gote forwarding report gote achi. Forwarding report gote achi. He was arrested.
Prepare a chart and give me. Day after, first day after. Day after, prepare a chart and give. And I am rejecting Rohit and
Pinky.
Rohit and Pinky I am rejecting, and rest of the people I will give.
Stringent condition because they are.
Oh yes.
Whatever condition you want, write and give. And I'll incorporate that. That's what I'm saying. Whatever condition you want, you simply tell. I'll impose those conditions. Yes.
Item 121.
May I please, Your Lordship, straight come to page 14. On last occasion, my lord, I have submitted while the present petition has been granted bail. And page 17 is the most important factor, the condition.
17. Yes.
He shall be released on subject to verification of the similar types of antecedent of the indictment. While he has been produced that copy, the London court below got an information that a case has been instituted against him at Calcutta by the NCB. While he has been asked, it could not be. He has stated so that neither any summon, nor he has been apprehended, nor anything else. That is
Therefore, I said, I told you last time, you filed an affidavit.
my lord.
Where is the affidavit?
नहीं,
I told you that you file an affidavit that I don't have a case. I'll rely upon that and
My lord.
allow you.
And so far as in Odisha, there is no case, nothing else, my lord.
Why don't you file an affidavit? That's what I'm saying. Last time you, 4th April, 4th December, I told you.
Can I
you
stop?
file an affidavit stating that I don't have any case. I'll rely upon that affidavit and I'll release you.
My lord.
As simple as that.
Tomorrow I will.
Tomorrow morning.
Kali बोलो वकील and तो you also granted 4/10/2024. Tomorrow. Oblige.
Yes, tomorrow.
ଆମକୁ ବଡ ନେଇଛି ସାଙ୍ଗେ ସାଙ୍ଗେ ଚିଠି କରି ଏନସିବି ଥିଲା ଯେ tomorrow day after tomorrow because I have to take instruction.
But he is insisting.
That is contrary that is
Day after tomorrow, you give it. Yes.
Tomorrow.
Day after day after.
Item 155.
You come. Yes. Yes. Yes, what are the allegations?
Sir, on the last occasion, your lordship
Well, the matter has been
used to
admitted
direct to file a better affidavit.
Affidavit? No.
Mm-hmm.
Well, this is what the case is. Well, the informant applied for the post of peon. Sipo. He got himself selected. Selected in the written examination, selected also in the physical test. Then the issue posted, then he was appeared for the interview. Then that the informant came in touch with one Linga Gomang. That Linga Gomang said that I can help you in the process of appointment. You meet one Asit Kumar Samal. Thereafter, he met with one Asit Kumar Samal. Asit Kumar Samal said, Asit Kumar Samal I am not. Asit Kumar Samal said, if you deposit the certificate with me and give me a sum of rupees 1,60,000, then you will be processed. Then what, to whom the certificates will be given? I am having two persons who are in the police department. One of the accused is myself. Then
he paid that money and
he has not paid that money. He otherwise is selected. Thereafter, what happened? He has deposited the certificates with that person Linga Goma. Then when he come to that Linga Goma, he said that you give the money and get back the certificate. Thereafter, he lost the affair.
Yes.
Well, I am the accused, and that Linga Gomang has got himself acquitted. Basing on the version of the complainant, because the complainant appeared before the court and said that I don't want to proceed.
You were absconding.
I was earlier on bail. Thereafter, I didn't appear somewhere. After receiving the notice, then
the original certificate you recovered.
Yes. Original certificate recovered. He is an employer because the after the certificate is recorded.
Recovered from whom? From you or from Linga?
From Asit Kumar Samal.
Not from you.
Not from you. I am no.
How many accused are there then?
I am no more in the picture.
How many accused?
4 number of accused.
4 number of accused.
So Lordship may kindly have a glance at page 27 last part.
That's the problem now. Insolvently is coming. What about the other accused person?
Other accused persons, how do I say, Your Lordship? I am in the, I don't know who are others. In my name, all the transactions were take place. Even I have not received the money.
That is not merit. Now you say that you have settled the dispute.
Then
who is the complainant?
Yes.
Complainant. Who is the complainant?
Yes, my
what about the other accused person? अरे केते जन ना केस फाइल करथिलो
केते जन लोक केते जन 4 जन 3
दोनों को धरते सर हम
हां
डरला पर हम 3 जन केते धरा पड़े
आगो केमि धरलो
थाना रेफर दे
ଆଉ କେସ୍ ଚଲେଇବାକୁ ଚାହୁଁନ ଆଉ ବାକି ରହି ଯାଇଛନ୍ତି ସେମାନଙ୍କ ଏଗେନ୍ଷ୍ଟ ଚଲେଇବ
ନାଇଁ ସାର୍ ତାଙ୍କର ବି
ହଁ
ତାଙ୍କର ବି କ୍ଲୋଜ୍ କରାହବ ମୋର ଭଲ ଅଛି ସାର୍ ଆଉ ସେଇ ଭିତରେ
The problem is the other people are absconding. Again, petitions will come. And I doubt whether he is extracting money from them.
No, it is a case, admitted case.
How much he has taken now? How much he has taken now for this case?
This person? No, man, I don't know because
You ask, he must be.
I have added him as the
He must be using these proceedings for extracting money from the.
Even your lordship, he don't even recognize me. This person does not recognize me as a counsel of the because I have added.
No, I'm not talking. You mean I'm not addressing you. I'm addressing your client.
Why?
Who is he? What is his name? Sankar Prushti जानते हो तमें? Sankar Prushti. हाँ?
ଜାଣିଛି ସାର୍
କେମିତି ଜାଣିଛ?
କେସ୍ ହେଲା ପରେ ଜାଣିଛି ନା
हाँ?
ଆଗରୁ ଜାଣିନଥିଲି ସାର୍
अच्छा. Four accused persons. Huh?
Total four accused.
total number four accused person
One accused.
Present petitioner along with other three accused persons. After investigation for alleged offences punishable under section 490, 420, 387, 384, 506 and 34. After investigation, charge sheet has been filed in this case on 30th June 14 against all the four accused persons. Against all the four accused persons for accused person for the aforementioned offences. Three accused persons, including the present petitioner, have been absconding. Whereas the third accused, namely Linga alias Lingraj Gamango, faced the trial. The SDJM Paralakimundi in trial number 291 of 2023 by its judgment dated 11/7/2023 recorded an acquittal in his favor. The had he supported the case in the prosecution?
He didn't support the.
Let us see, where is that?
Page 29, your lordship. That the judgment and the internal page 6, page running page 29.
Examine
Paragraph 6.
Yes. The trial court, while its judgment dated so and so, has inter alia returned the following finding. Page 29, para 6. Next paragraph. Relying upon the aforementioned finding of the court below, and on the ground that the parties have settled the dispute, the present petitioner is seeking indulgence of this court for quashing for the entire criminal case was quashing. The petitioner and the opposite party number 2 are present in the court, being represented by their respective and also represented by their respective counsel identified by them. They have also filed self-attested copies of their Aadhaar card, affidavit, Aadhaar card, which are taken on record. But the opposite party number 2 has also filed an affidavit before the court.
fresh affidavit
Dated, date which is 25/11/2023. Inter alia stating as under. Para 2/6. On the inquiry from the court, the opposite party number 2 submits that he has already settled in his life and he doesn't want to proceed against the present petitioner and also against any other accused person. Regarding Pratap for the state and submits that the dispute is in fact the inter se party. They have settled their dispute. The petitioner has filed, the opposite party number 2 has filed an affidavit before the court. Therefore, there is no legal impediment requiring the FIR. Next. regarding had to the finding arrived at by the court by the learned SDJ in its judgment dated dated 11/7/2023, and the fact that the parties have pronounced the dispute and filed affidavit for the court, the prayer of the petitioner deserves merit, particularly in view of particularly in the light of the judgment of the Honorable Supreme Court in Yansing so and so. Therefore, subjecting the petitioner to the rigors of trial is destined to be a futile exercise. Hence, the petition deserves merit. Accordingly, so and so is cost, subject to the petitioner paying. How much cost he pay? 2,000. Yeah. Subject to the petitioner paying a cost of rupees 2,000 to the informant. To the informant, so and so is cost. Yes.
To the informant. To the informant.
Yes.
At 122.
Yeah. 133 compromise. Okay, 133. Yes, 133. What are the offenses?
Offenses 137, 296, 351. BNS read with the 3-5 of the BNS. Joint affidavit.
Kidnapping. 296.
Last occasion, the informant was there, but the victim was not available, was not present. That's why your lordship posted the matter to another date, that is posted today. Today, the victim as well as the informant both are here present, including the
Lordship, the FIR, Lordship, kindly have a glance at the FIR, Lordship. At fifth line, your Lordship.
Yes.
Case. In the mutation case, the Lordship, the petitioner, who is the recorded tenant in the consolidation, has not been noticed. And the land is fraudulently recorded by the Tahsildar and in the name of the opposite band number.
Delay, how much delay?
No delay, my lord.
Yes.
No, fixed
Notice was issued.
5 to Rocky, the postal.
Despite notice to opposite party, NDPS for the petitioner. You have no objection. Correct. We are for the reasons with the application, the same is allowed. WPC number 17187 of 2010 is restored to its original file, and let the writ petition be listed on the assigned bench for disposal. Yes. Subject to permission of the Honorable Judge. Yes.
At 124. The transfer application. Petition on file. Transfer application. Transfer the case from Kendrapura to Kotak. And when the material scheme, the petition as the case for default. I find the restoration case.
No, the transfer, which proceeding you seek transfer?
Civil proceeding.
Where is that?
Civil 315
315
CP number 315 2022.
It's still pending or it is over?
That is pending.
Pending. Nothing is happening. What is the delay here?
Delay 4 months.
4 months.
Notice has already been issued.
Este service the just see. See the service position.
The opposite party appeared also.
Nobody is there today. Last time also nobody appeared. Service complete, na?
Yes, sir.
Well, despite service, the opposite party, none appears for the opposite party. In the previous hearing also, the opposite party did not appear. In this petition is seeking recalling of the order dated. Order dated.
Order dated
Recalling of order dated 15/11.
28/6/2023.
Huh?
28/6/2023.
28/6/2023, whereby the 11th single judge of the
Next
court
one.
has turned has dismissed the TRP bracket C number 128 of 2023 for non-prosecution. Next one, for the reasons stated in the application, the petition is allowed, and the TRPC number shown to the restored to its original file. Release the matter for final disposal before the assigned bench, subject to permission of the honorable Chief Justice.
Item 125.
I owe responsibility for by mistake, Milord, for long delay.
Delay, how much?
Yes, Milord, delay is 7 years.
7 years.
Milord, that is delay. Milord, usually, Milord, the case, I owe responsibility for that because in any mistake, in the summer 2017, this has happened, Milord.
So what will you do by restoring?
Only
2004 writ petition. What is this writ petition is about?
It is relating to consolidation order. The consolidation order I objected and it was torn down. Then I carried in appeal and appeal also overturned. Then Milord, that is Milord only restoration I will on any date.
2,735 days delay.
Yes. Milord, only one.
There is no sufficient cause also.
Inadvertent mistake. Milord, opinion number 9 was all of the opposite party didn't appear. Only one opposite party appeared. So
that apart, but you have to give sufficient cause.
Yes, yes.
For
Yes.
such a huge delay.
Yes, I owe responsibility.
Yeah,
Only
unless
number
you
9.
you file affidavit, better affidavit.
No, only opinion number 9, your lordship say any cost I will give. Only
No,
one opposite
I'll
party.
just issue notice on the petition as well as
Yes.
condemnation of delay application.
Yes, my lord.
Issue notice, let us see. If they oppose, then we will.
Well, any returnable date so that.
He'll give.
Oblique, triple oblique.
February returnable. Issue notice. Returnable.
Yes. Only 4 to 9. All other the government opposite party, state opposite party 1 to 3. 4 to 9 notice to.
4 to 9. Issue notice to 4 to 9.
Let's since of all. Let other opposite party 4 to.
I know,
8.
I understand. 4 to 9 kar diyo. 1 to
3.
1 to 3 he accept notice. And 4 to 9 issue notice. Yes.
My lord. Oblique, my lord.
I don't
want condemnation of delay also. Both,
My lord?
both. Yes.
Any returnable date so that.
He'll give February.
Yes.
Yes.
Oblique.
Item 126.
Yes, sir.
It's a restoration of a regular first appeal.
Delay.
Delay is more than 3 years, my lord.
Same order. Notice to
All are private parties.
notice to opposite parties. Notice on delay also. Yes.
Good.
Item 127.
Restoration petition, there is no delay, madam. There is no delay. The restoration.
Restoration.
This is for default on 31st/3/2023.
31st March 23. For the reasons stated in the present petition, the same is allowed. The what is this? Criminal MC. What are you asking in that criminal MC?
Having the order of cognizance.
2019 cognizance. By now, I don't know what might have happened in the trial.
There is an interim order.
Huh?
There is an interim order.
Stay.
Council for the state in direct.
Then I'll simply issue notice, nothing. Issue notice. Only issue notice. Don't do it. Issue. There is opposite party also. Issue notice to opposite party, written so and so, or so and so accept notice for opposite party number 2.
The main case notice has not been issued.
I'm issuing notice then. I'm issuing notice. Yes. How to sleep now? Restoration. No. Restoration is no kar raha hu. Only notice. Simple. Yes.
Item 128.
Well, a conversion of the nomenclature from CRLC to CRLA. As there is a OPID. I have filed the IA 3210.
3210 of 24 I. As
3210.
my lord. The SR pointed it should be CRLA because of OPID. I have filed CRLMC. For that reason, I have filed the conversion. IA for conversion of CRL.
CRLA.
My lord.
For the reasons stated in the application 3210. The nomenclature of the present petition, the registry is directed to change the nomenclature of the present petition from CRLMC to CRLA and renumber the same, and thereafter release the matter before the appropriate bench. Yes.
Okay.
Item 129.
For extension of time. This was the case.
How many time we extension? First order was 12/8/2024.
Thereafter,
He was
6
asked to
September.
appear 31st August 2024, and he sought October 24, December 24, right? The petitioner is seeking modification of the extension of time to surrender as per the direction of this court dated 6/9/2024. Earlier, the petitioner had moved 6/9 dated 12/8/2024. Earlier, the petitioner made the similar prayer by filing CRLMC number 4199 of 2023. This court, by order dated 6/9/2024, extended the time to surrender before the court up till 15th October 2024. Instead of surrendering, as per the direction of this court, the petitioner has preferred the present application. Which application is this? Seeking further extension. Seeking further extension. Further extension for a period of 4 weeks. 4 weeks. I am not inclined to extend the time to surrender. Extend the time to appear or surrender before the court as per the order dated 12/8/2024, because the petitioner has already availed one extension. One extension. Accordingly, the application is dismissed. Yes.
Item 130.
My lord's mediation is adjourned to 7th January of 2025.
Mediation.
My lord, my humble prayer is consider my IA, my lord.
IA for?
IA for stay, my lord. Stay of the
mediation is going on what stay?
My lord, on the first date he has appeared, and on the first date he has appeared. After that he only.
No, mediation is going on. I can't do anything. Right. A mediation process is still going on in the present case, and the matter is stated to have been slotted for hearing on 7th of January. This is the matter after January.
Okay.
Item 131.
May pardon, my lord. I am in VC, my lord. My lord, petitioner is a father-in-law and mother-in-law challenge the order of cognizance.
Yes, to take
service
My
on
lord,
opposite party number 2.
Opposite party number address available, my lord, in annex page 12, that is the FIR address. After 5 days of marriage, they leave the matrimonial house and go outside, my lord. Address available is the FIR address is the address supplied by the opposite party number 2, my lord.
The petitioner has not furnished the fresh address of opposite party number 2 as per the direction and of this court dated 6/11/2024. One more opportunity is granted to the petitioner to furnish fresh addresses for the opposite party number 2. This is the matter. Yes.
Item 132. Adjourn, my lord. My lord.
You have not furnished the addresses as per earlier direction. Next.
Item 132.
Supplied,
Please,
madam.
Your Lordship.
And you arrange and supply them.
Yes, that is the direction you have not complied. Yes, yes, madam.
My lord, I'm appearing on behalf of the opposite party number 3, my lord. My lord, the whole issue is about the scheduled property. which is the
132.
132, my lord.
Yes.
My lord, the scheduled property is the self-acquired property of my father, my lord, the opposite party number 3. And the petitioner is the cousin brother of the opposite party number 3, my lord. Before, my lord, the opposite party number 3 is a married lady and she used to stay, not stay in her home. So, my lord, after the death of her father, now she has cultivated the plot. And because of the disturbances, he has filed the 144 proceeding before the subdivisional magistrate, which has been, my lord, which, against which the petitioner has also filed the objection. After that only, my lord, the order has passed and the petitioner has been restrained from the scheduled property. And this season, my lord, I have cultivated the whole plot and their only proof of the position.
Show me the finding that you have cultivated.
My lord, I have filed in my objection. I have also taken the crop.
How the magistrate has dealt with that? Come to that.
My lord, initially.
This is again disputed fact. Who has cultivated?
13 numbers of plots. Out of which only one number of plot has been cultivated back in February 2024, my lord, which has by the petitioner, which has been also written in the report of.
Show me something from the record.
Yes, my lord.
That you have cultivated. Otherwise, these are disputed fact. How will I believe?
My lord, I have submitted Annexure 1, the crop insurance taken by me against the crops I have cultivated. And my lord,
you have insured.
Yes, my lord.
Yes, show me.
The counter affidavit filed by me, my lord.
Counter.
Which one?
Page number, the counter affidavit, my lord, page number 8 to 10.
Counter affidavit 8 to 10.
Yes, my lord.
Yes. Oh, it's not. Nobody can see it. What here? Yes. Yes.
My lord, this is the Kharif season, my lord, and they have no submission that they have cultivated any crops this season, my lord. That was the previous.
You have insured that crop.
Yes, my lord.
This year.
This year, my
season. Why I am not able to read it? Because
my lord?
I am not able to read it. What do you say?
My lord,
The
proceeding.
It is insured.
I have got the document they have provided me. The same document for the year 2023 and 2024. For that, not filing in shape of affidavit. I have the document. They have also insured. My lord, a proceeding was initiated in the month of January 2024. The Honorable Magistrate called for a report on the Tehsildar and the local IAC. The IAC only stating 2 lines that there is apprehension of the likelihood of apprehension of breach of peace. The Tehsildar gives a report, I have annexed, my lord, finding the possession of the present petitioner. There is a report to that effect, my lord. So after 5 months, my lord, in the month of June 2024, a restraint order has been passed against the present petitioner not to enter upon the scheduled property. The petitioner was cultivating the land, and admittedly, that is the report of the Tehsildar. I am in possession, my lord.
But if you are cultivating the land, why she has insured, her client has insured?
No, I have the document. I can file it, my lord.
This for the previous.
It's just completely regarding the title of the right title interest or the suit. It's completely a civil dispute, my lord.
No, that's not the issue. Civil dispute may be.
My lord,
The crop is standing. The crop is standing.
The crop is
standing. She has, her client has insured the crop.
I can file it in shape of
That's for
affidavit,
the
my lord.
previous year, my lord. And my lord may see Annexure 4 and 5. It is clearly written that only plot number 538 is like cultivated by the petitioner out of 13 numbers of plots. My lord, this season I have cultivated the whole land and they have not cultivated a single crop.
I
my
can
lord.
file the documents, my lord, I have the documents.
Actually, the document is very telltale.
My lord,
This document which she relied.
my lord, I have the same
very clear.
documents 23 and 24. Since it's with photocopies of the same, my lord, I can also file, my lord. We have also insured for the year 2023 and 2024. And to take care of this, there was a dispute. The lordship may see order dated 6/9/2024.
6/9?
2024.
Yes. 6/9/24. Yes. Yes.
My lord, the second paragraph, my lord, the learned counsel proposes stating that standing crops are there in the event interim order is not modified, the crops would be damaged. As a result, will sustain financial loss. Without entering into the controversy, the jurisdiction of the Tehsildar has given notice. The Tehsildar has given notice. Tomorrow, both the parties will appear, will go to the scheduled plot. Tehsildar here for tomorrow is the date has been fixed for tomorrow.
My lord, it has been.
Let it be over, my lord.
My only.
Nobody is prejudiced.
There is a direction. It will be the crop will be crop will be cut and it will be sold. And if you are entitled, you will get the money. If he is entitled, he will get the money. What
My lord, when the petition, they have claimed that they have cultivated.
so
the
that
crop.
I will adjudicate. Right on. This. What are you seeking in this matter?
My lord, my only.
Order dated 13/6/2024.
So what remains then?
Nothing remains.
In this matter, nothing remains.
If at all, my lord, they can approach the appropriate forum to declare. Because I have advocated, cannot be decided.
My client has taken loans and cultivated the crops, my lord. If that will
See, therefore, the earlier bench of this court has directed that the Tehsildar will go and cut the crop and sell it, and that sale proceed will be
deposited before
given to you or him who
my lord,
established the right.
My lord.
And what will you do with 145 proceeding?
My lord, it will be deposited before the subdivision magistrate.
Right.
My lord,
It has to be decided. See, in 145 proceeding, I can't decide your title.
Yes, my lord. That.
And only the crop will be sold and it will 145 proceeding. What is remaining?
They're only claiming the property on the basis of ki my father.
Madam, you have civil remedy. 145 court can't do it.
Yes, my lord.
Those were limited
The matter is completely civil in.
I will dispose it up in view of this, and you keeping it open for both of you to get your right indicated. Right. The petitioner in the petitioner is seeking quashing of the order dated 13/6/2024 passed by learned SDM SDM Jharsuguda in CMC number 6 of 2024. Which annexure is that?
My lord, annexure 6, page 29 is the order.
Whereby the application of the petitioner,
opposite party had
opposite
filed.
party number 3, under section 145, 140, the proceeding initiated by the opposite party number 3 under 144 CRPC. Has been allowed, and the petitioner has been petitioner being the second party in the said proceeding has been restrained to enter into the above scheduled land for a period of 2 months from the date of passing of the restraint order. That order is also left 2 months. Notice was issued to the opposite party number 3 by the order dated 7/8/2024. Opposite party number 3 has filed counter to the petition on date में कुछ भी नहीं होता है, डेट में कुछ नहीं Whenever we file this counter, madam, there is no date. Counter date. There is no date in the counter. I will have to go by the seal which is filed 28 August 2024. In the counter affidavit, the opposite party number 3 is relying upon an insurance document, and claims that the crop standing in the subject land belongs to him, and as he has he has insured the crop. On the basis of the said document and served document, opposite party number 3 submits that he is in fact entitled to the proceeds of the crop, proceeds of the crops. The counsel for the petitioner, on the contrary, is also on contrary, counsel for the petitioner also hands up insurance document regarding the same crop for the year 2023 and 2024. I have perused the entire document. I have perused the entire petition and related document placed before the court. It reveals that the order, the impugn order, which is under challenge, was effective for only 2 months. That apart, the coordinated bench of this court, by the order dated 6/9/2024, has directed as under para 3, 6/9/2024, para 3. In view of the aforesaid direction, according to me, nothing survives in this petition. The claim of the claim and counterclaim of the petitioner and opposite party number 3 regarding the ownership of the crop standing in the subject land cannot be decided in this proceeding. The coordinated bench has already taken care of the interests of both the parties and directed the Tahsildar to cut the crop and sell it in the open market and deposit the sale proceed with SDGM Jharsuguda. The petitioner and opposite party number 3 are at liberty to resort to the remedy under law, for determination of the right over the land, in appropriate proceeding. With this observation, the petition is disposed of.
My lord, only one prayer, my lord, may give any direction to complete the CMC proceeding within your particular.
What CMC proceeding is over? There is nothing survives now. Because that order was CMC proceeding, the order was restrained for 2 months. That is over. Now the dispute is about the crop.
Yes,
That is taken care of by the coordinated bench order.
okay.
Then nothing survives. You resort to the remedy. If anything happens, then start another proceeding. Who stops you? There is no res judicata. You can start another proceeding under 144. Yes.
Item 134. I beg your lordship's pardon. Item 129 on extension of order, my lord.
129.
I could not attend the court, my lord.
I don't know. I passed some order. I rejected that. Right. Rejected. Yes.
Lord, item 134, my lord, Belgium matter. Bail was granted 5/12/2015, my lord.
Which one?
134.
34?
Belgium matter, my lord. Bail was granted 5/12/2015.
134.
27/9/24.
NBW was 27/9/24.
24.
Yes, my lord.
Yes. 500.
My lord, I for dispensing with IFL.
Dispensing for what?
The IA dispensing with the certified copy of the NBW.
Allow korto. Chalo. Yes.
Item 135.
Item 135, lordship.
I have filed for a suspension of sentence.
Way
This
back in the year
matter comes under
2013. IA was filed way back in the year 2013.
13 for suspension of sentence.
Yes.
Let's say this matter comes under orders. May I kindly be
Maybe tagged in the
tagged for a hearing.
weekly list for under hearing.
Weekly list.
So also, my lords, item 136, 137, and 138. All are appeal
Yes.
up to 138 minutes.
This is weekly
It's
list.
conviction. This is
Weekly
weekly
list
list.
started?
Weekly list, my lord.
No, these are weekly list or what?
Yes, my lord.
Yes. No, it's not weekly list. It
Yeah,
is
today's list is weekly list, my lords. So it has come under the heading of orders. That is a difficulty. It should come under the heading of hearing.
hearing.
Yes.
Last application, 130 also directed for adding this cell to the hearing list, but in under the order of the hearing with that.
136.
Up one 135 to 139 minutes. All can be heard, my lords. It's all ready for hearing. Can call
So
under the hearing.
that can go there only.
Yes.
Weekly.
Yes, my lords.
If lordship permits.
Your lordship, I have filed already consolidated a cost title file.
Set
Already
a-
filed my lord. Final year.
That's what he said.
Yeah, under
Same thing.
under my lord, all these matters may be listed under the heading of hearing. That will be convenient.
It's hearing.
Well,
Yes.
great.
If lordship permits.
135 to 130.
139.
39. Hearing recording. Order se likha hai hearing recording.
If a lordship permits, my lord, I have a submission, my lords. My lord, your lordship, just refresh your lordship memory. Last occasion lacks both the appears, my lord. In this case, my lord, Mr. Rai already completed his argument. I have to submit the note of submission. Item 161, my lords. And my lords, it will I not take even 3 minutes, only 2 minutes, because if lordship can to refresh your memory.
161.
161. Well,
160, my lord.
I'm not.
Mr. PK Ray has already concluded his argument.
Your lordship can glance to the note, your lordship.
And he has to file only written note.
Your lordship can see that notes, your lordship given to me, my lord. That was filed by the Mr. Roy. This is the thing, your lordship wanted me to take instruction on these matters, the calculation he has made. My lordship can look at the note of submission, my lord. I just placed only, my lord, these are actually in the chart sheet, the D amount was 39%, lots, and as per this particular calculation, it comes to 7%, less than 10%, bro. My entire summation is paid with one thing, lots. This is not this particular calculation, and the note of submission is not part of the chart sheet. And secondly, lots, these do not relate to the materials or chart sheet produced by the prosecution for which.
My lord.
Yes,
already have seen, my lord, but he has not given. They are given to see this.
Okay. That's all. And secondly, my lord, I have given one decision that the honorable court should not put themselves in the shoes of the chartered accountant to find out the similarity.
My lord, may reserve for order because we have already.
No, I will not reserve because I have reserved enough.
No, your lordship.
Don't watch my 40 judgment. I have throw this paper and go without.
No, my lord, we have given the note of submission and citation, everything.
To my limitations. Right. Yes. I keep it on 7th. You replied 7th. A small hearing.
And lordship permits, my lord. Justice President was who hails from the Madhya Pradesh, my lord. So he will be getting all those matters the last day before vacation. मेरे को इतना बाहर लेके कहाँ नहीं जाना.
The vacation is gone.
Carries all those files. With
people say that they are taking vacation. That's not the truth. Truth is otherwise.
A short.
Yes. 7th. Yes.
As a to be mentioned category.
Orders category.
To be mentioned because it will not reach. To be mentioned.
Orders category.
Yes.
Put it on, right.
Item 140.
140, my lord, I am appearing for. Lordship may call this matter after vacation.
Yes.
140, 41, 40. Added to the hearing is.
So far 140 is concerned. So Mr. DP Nanda is appearing for the appellant. He will conduct this case. Lordship may call this matter 2 weeks after vacation.
2 weeks after vacation.
During that part of
Many matters is not possible at all.
So last week-
January last week. No, February beginning. of it. February beginning. of it.
141, 142. Obliged.
Yes.
There are stay of convictions application under this, and they are proceeding with the disciplinary. They might terminate my service in a specific date.
Yes, he give a date. Yes.
I do 144.
143 is also mine. 143, my lord, I have the petition, or there are other petitions.
143, somebody, the senior counsel mentioned in the morning.
Say old, that is the old matter.
What can I do? It is mentioned. I told him, you inform.
Or there's the opposite parties. They are in.
But he mentioned it. His personal difficulty.
No, can you fix a date in that?
Date is has already been fixed.
Again?
Date has already fixed. Yes.
This is 144. Here, my lord, I have sought a review of the order.
Yes.
In Annexure 1 is WPC 7596 of 14.
Yes.
The order is of at page 14.
Yes.
My ground of there is an also interim order, my lord. By suppressing the material fact that there was an earlier order of this honorable court in WPC 6803 of 2010.
Now, have you implemented the review petitioners?
Yes, yes. Yes, their parties they have appeared. They have appeared. Somebody name is there on the first day.
Yes. Yeah, what are the grounds for review?
My lord. WPC 68, this is, my lord, the fact is for the post of peon in a particular institution. 2 posts is eligible as per the new grantee policy of 2008 for the payment of grantee. There are 4 incumbents now. They are claiming. So the petitioner in that 6803 of 2010 is the senior most. I am appearing for her.
Yes.
There was in that writ petition, my lord, a direction was given to the director because a list was published by the director. Objection was called for. We filed the objection. When no action was taken, I came before the honorable court. Direction to the director to cause inquiry by giving opportunity of heard to all the parties. In that case, notices have been issued. All the parties appeared. They took time there for some plea or other. And the till date, the matter is pending with the director. But by suppressing that order, where they have contested before the director, I have given the notices also here in this review petition. They have filed these opposite part of 4 and 5. They have filed this.
Yes.
Writ petition WPC 7596 of 14.
So there your ground for review is suppression.
Yes.
Order 46. Yes, CPC.
They are the parties. They know that
maybe, but whether suppression CPC suppression which clause? Order 47.
That is why, my lord, when I have brought this note.
No, you tell me order 47. Come to order 47.
I have not brought the CPC.
You are arguing a review petition, you don't have a CPC, then how will you argue? I'll give you a book. I'll give you. Yes. Which clause you are covered? Suppression of material fact. Review.
Under the High Court rule, not especially.
That will not supersede order 47.
Which one?
Order, you tell me order 47, which clause you are covered? Suppression of fact by the petitioner.
Application for review of judgment. Any person considering himself as aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small causes, and who from the discovery of new and important matters on evidence, which after the exercise of due diligence was not within his knowledge or could not be
So first ground is a document discovered
my lord.
Which is not
That
only
is-
knowledge,
that is for
that is
petitioner.
background.
Plus two.
Next.
Two.
Read it.
A party who is not appealing from a decree or order may apply for review of the judgment notwithstanding the pendency of an appeal by some other party except where the ground of such appeal is common to the applicant and the appellants, or when being respondent he can present to the appellant court the case on which appeal for the review. Because we are litigating in that particular case. That part was not brought to notice. Now the order has been passed here by rendering my earlier case where the direction was given, that is virtually infructuous by this order. So now in this case, writ petition, the court has directed because that order which are now excelling in the previous writ petition, which is pending before the director.
Show me that previous, your party, all of your party.
No, earlier writ petition, in this writ petition where I have filed for the review, there he was, I was not made a party. I filed this review. This writ petition, if I see my annexure 1, the cause title comes.
Yes. Pavitra Lenka.
Yes.
Pavitra,
No,
you are
page-
Pavitra Lenka, Gangadhar Rao.
Annexure 1, page 12.
Rao. Let us see.
Page 12.
Page 12, I am there.
These two persons have filed. We are not made parties. But kindly see the notices at page 28.
20?
Annexure 7 series, 28.
28.
By the director. In
Yes.
connection with the pending cases where we are litigating.
Yes.
All these
Where is
cases.
that
There are 2 to 3
Where is that
cases.
Yes.
Also. Well, page 29 times.
29.
29. This is from the directorate to the secretary, WPC 6803 of 2010, Pratibha Lenka, the present review petitioner. I have filed the 2010 case. The DSG has been pleased to fix up the
Hey,
date.
show me the earlier order of the High Court. Earlier order of the High Court, show me. He might have issued notice. How do I know whether the court has asked him to issue notice? Show me the earlier order.
One copy, I am reading out.
That is your entire case.
Yes, my lord.
Where is that order? Show me that order.
That is there. Thanks.
Read that order.
I am reading. Small order.
Yes.
This was the 19/4/2010. Petitioner, it is submitted that appointment against the first post of peon of Hon'Ble Women's College, Saradpur, in the district of Bhadrak. Her grievance in this writ petition is that while recommending the name of eligible staff who are eligible to receive grantinate, illegally the governing body of the college recommended the name of the opposite partner of 4 and 5 instead of the petitioner. I made them the pass. Being agreed by the petitioner, the petitioner has approved this post. And counsel for the state, on the other hand, submitted that the governing body is the sole authority to decide the interest seniority amongst the member of the staff of the college. And as such, this writ petition is not maintained. In course of hearing, however, it appears that the petitioner has already filed a representation before the Director Higher Education of Post Part 2 on 1/2/2010, seeking the self-same relief. The grievance of the petitioner involved disputed question of fact which cannot be effectively adjudicated under the writ jurisdiction. This court therefore disposed of the writ petition, directing the Director Higher Education opposite part number 2 to dispose of the representation said to have been filed by the petitioner on 1/2/2010 strictly in consonance with the law as expeditiously possible if this time is still pending. So therefore, notice has been issued by the director. All these parties, this petitioner in the opposite part number 4 in this review petition.
In the earlier writ petition,
I was the petitioner.
You are the petitioner.
I was disputing that recommendation of the governing body in favor of this opposite part number 4 and 5. There, my lord, direction was given, you consider it, right, in accordance with law. There, my lord, on receipt of the order of this honorable court, director has issued a notice. Not once, that is why I was showing, my lord, page 29 of the bill. Notices have been issued in that particular case by the director, even including these two persons, opinion number 4 and 5. Kindly see, my lord. I have given 1 to 2 notices. 2 notices I have given here. Kindly see. One on 8/9/11, another on 15/9/10.
Show me the writ petition, copy of writ petition. There, this writ petition. 7596. What is the amendment made? Concealment, you say concealment. Let us see whether concealed or not.
7943, they have not made us parties.
Only tell me whether they have concealed or not. Show me the pleadings. No important documents you have not filed. Your entire case is based on those things. You have to file those documents. I don't know. You don't have a case, you are trying to.
No, I have a strong case.
You don't have a case.
No, I have a case.
It's not a case for review. Learned counsel for the Mr. Das, learned counsel for the petitioner seeks an adjournment to place on record the additional document to substantiate his case. Let him do so within a week, leave the matter after the second week or third week. Yes.
There is an interim order, it will continue.
Item 145.
Well, last occasion, relying on that judgment by the Supreme Court, I was placing this case because of violation of Rule 25 of the Dozen Cosmetic Rules. The Lordship wanted to know the expiry date. That is there in the complaint petition itself by on anyhow.
I have forgotten everything.
Well, my lord, then it's very short matter. My lord, what has happened in 2007, 22/2007, the
date chart दरकार है ये detailed date chart
date chart
गोला date मध्ये direction लिखला senior
note of this note हम कर दीजिए note कर दीजिए
हमें date chart दो so that because that case was on the ground that content was registered and delay of 1 month from what for after the expiry. For that reason, court was quashed that proceeding. But here this is not that case.
But complaint petition is sufficient. My lord, here the
complaint petition.
Yes, my lord, page 17, my lord.
17, huh?
Whatever my learned friend is there in the complaint.
You are the occupier.
Yeah, I am the manufacturer. But in manufacturer.
Yes, 17 plus 6. 17.
Page 17.
Date and time.
That on 22/8/2007, Sri Lalit Kumar Sahu, the then drug inspector, Balangir Range, Balangir has done statutory sample 4 portions into so of the drug so liquid.
Where are you reading?
Page 17, my lord, complaint petition.
Yes.
Para 2. Para number
15/7/2008.
28/7, no, page 17, 1/7. 17.
22/8/2007.
That on 22/8/2007. Let's see what it may. On 22/8/2007, Lalit Kumar Sahu, the then drug inspector Balangir had drawn statutory sample for of the drug Vizag liquid number so and so. Expiry date is 8/08/2008. So the manufactured by Mrs. 3B Healthcare Limited, then opposite Dental College Rampur Road, Patna Sahib SP, from the sales premises of Mrs. New Delhi New Life Medical Care at post so and so. And next for the purpose of test and analysis of sealed portion of the drug 1/200 ml of the Vizag liquid was sent to the government analyst state drug testing research laboratory Bhubaneswar by form number 18 drug inspector Balangir memorandum number so and so for the purpose of test oblique analysis.
Yes.
That the government analyst state drug inspector declared the above mentioned drug as not of standard quality on the form 13 test report and on 15/7/2008 as the sample is of not of standard and then para 2 election can see next letter that as per the government of Odisha Health and Family Welfare notification number so and so, the undersigned took over the charge of the newly created office of the drug inspector Sabanpur Range on 1/10/2009 along with related document that the portion of the drug sample as required under section 23(4)(3) and copy of the test report form 13 as required under 75(2) of the Drug and Cosmetic Act 1940 was sent to the manufacturer 3 so and so and Himachal Pradesh by ratio with AD with drugs inspector Balangir by letter dated 26/7/2008. By 22/8/2007 they had and 26/7/2008 because the expiry date was 8/08/2008. And in response to this manufacturer, he furnished a reply by letter dated 22/8/2008, wherein, as per statute, Lordship kindly at this stage, Lordship kindly see the provision 25(4).
the judgment, the 25 Act.
Have you reproduced
Rule 25
in the petition?
Yes, my lord, page 8 I have put it. Page 8.
Yes.
Sorry, section. Page 8, para 6.
Yes.
Let's see what it meant. 25(3). Any document purporting to a report signed by government analyst under this chapter shall be evidence to the fact stated therein, and such evidence shall be conclusive unless persons from whom sample was taken, the person whose name, address, and other particulars have been disclosed under section 18A, as within 28 days of the receipt of a copy of the report notified in writing the inspector of the court before which any proceeding in respect of the sample are pending, and that he intends to adduce evidence in contravention of the report. 4. Unless the sample has already been tested and analyzed in central drug laboratory, where a person has under subsection 3 notified under his intention for adducing evidence in contravention of government analyst report, the court may on its own motion or its discretion at the request either of the complainant or the accused cause sample of the drug 3 or the corresponding produced before the magistrate under subsection 4 of section 23 to be sent for test or analysis to the said laboratory, which shall make the test or analysis and report in writing signed by you under the authority of the director of Central Drug Laboratory, the result thereof, and so on. Then you will also kindly see our reply. My lord, when they served us the report, my lord, as per 25(4), we page 25, my lord. We immediately within 20, because right it's conferred on us to seek for testing by central laboratory within 28 days. Let's kindly see page 25.
Yes.
This 22 August 2008, page 26, my lord, last para, sorry, para 2. As per report of the government analyst, it has noted the sample of this item has been drawn for testing on 23/8/2007, and government analyst had tested this same on 15/7/2008 for after a gap of 12 months. Then last para. So we are not satisfied with the findings of the government analyst, State Drug Testing Research Laboratory. Also, we do not accept the result of the report of the government analyst drug testing research laboratory Bhubaneswar under detail number so and so, and we intend to adduce evidence in contravention of the same, and thus we request your good self to kindly send the remaining portion to the sample through the Hon'Ble Court concerned to Director Central Drug Laboratory, Kolkata, for retest and reanalysis as per the section 25(3) and 25(4) of the Customary Act 1940.
Yes, to pay cost and all. Yes.
Sir, my lord, Lordship, kindly see this that judgment, my lord. The other day, Lordship had seen it. I have filed along with the note I have filed. That
yes, Mr. Jana, you.
And that is very, that after reading the judgment, Lordship, that the Lordship wanted to know the expiry date. Expiry date, my lord, it is there in 2/8/2008. And the complaint was filed in 2012, 2012, 5 years after. And after that, my lord, Bolangir drugs inspector on 5/8/2008, 5/8/2008, madam. Test report and request for retesting the sample, my lord, Kolkata, immediately knowing the fact that the sample is going to expire in the same month. We have given him the report, my lord, on dated.
That is what I asked, when the expiry date.
Date chart is necessary, my lord. Date chart is necessary. Because they were technical lies. One date, my lord, that in that case, my lord, what happened? The complaint was filed later after the expiry of the drugs, my lord, that was sent for a chemical examination. But here, my lord, the drugs was sent in time, my lord, and subsequently he was noticed and he's replied to test that in compliance to
25, 3 and 4.
Yeah. For that, my lord, only 2 days expiry was there. For that reason, my lord, even if, my lord, we sent for testing, my lord, it cannot come, the report cannot come.
Then I accept it, you respond to it by giving a date.
Your lordship may keep it some other day by
second week. You want to continue? Further argument. Written submission you have to file.
खाली वो डेथ चार्ट दे दें
Interim order that interim order to continue.
much obliged.
Yes.
Item 156.
146, here and the. Right. I'm for the opposite party.
Who is for petitions?
My complaint was sent under section 156(3). That has been challenged.
Yes.
And the learned court, in fact, I was cautiously going through the impugned order. What I find, subject to your lordship's appreciation.
Where is the complaint copy?
Complaint copy, the petitioner has annexed. No object. Page 22. Oh, yes, yes.
20?
22.
Have you said there is a verification? Is there affidavit? Is there?
Yes. And the impugned order is at page 65.
65.
It starts with 64. But
yes.
Given a very reasonable and also quoted the judgment of this honorable court as well as honorable appeals court. This is the point of law government between skill to that.
But somebody has to be there. Or simply at the March. Nobody appears.
And one more thing.
There is no stay, nothing.
They have taken a no coercive action. I don't, because they are absent, I don't say that. That has to be. I need to be. Here the state is also a party. What I pray, your lordship may take up on some other day. This
very
156.
No coercive action means what?
Well, because they are bank officials. They were apprehending or something else. I do not know how. Anyway. And what progress the investigation? In fact, that will suffice everything. It's a case of 2020. Order of 2020.
What is the stage? At least you tell. There's 156 order.
I would not have opened in absence, but because my client is suffering at a third stage of
second week of January.
Third stage of cancer. That's why.
What to do? Second week of January. First week. Non-APS for the petitioner. In the interest of justice, urgent to so and so. Mr. Das APS for the opposite party. It is made clear that no further adjournment shall be given on the next date appearing. If the petitioner remain absent, the interim order earlier pass shall be vacated on the next date appearing.
And my friend may that instruction on the
Mr. Janna, the state council is required, Mr. Janna, council for the state to obtain the instruction regarding the status of the investigation. Yes.
My information that it has not been registered till date. Let my friend. No coercive interpretation कौन है क्या?
Naturally, that is the problem. In the investigation stage, if you say no coercive action, then this is bound to happen.
For a factory, I took the loan. The component has to be supplied by Ajmer company. The bank has given the money to them. They have not supplied the component. My entire loan, and which was a redevelopment of my existing business, ruined. They recovered the money to the account. In spite of a due diligence negative report.
Yes, next.
Item 147.
Present information of the staff of the municipality, the presentation of the assaulted while the measurement is going on. That is the release.
Who is appearing for petitioner? Interim order is there, so that is the reason. Nobody will come. Once you grant interim order, this will happen. I have none appeals for the petitioner. in the Court of Justice urgent to so and so. It is made clear that on the next date of hearing, if the petitioners will not appear, if not to appear, the interim order passed earlier shall be vacated. What to do?
Item 148.
148. Senior counsel Mr. Kanungo is appearing. Can I pray for tomorrow? Day to tomorrow?
Not tomorrow. It will go to March. On the request of the petitioner, interim order is there.
Interim order is the will file on petition for adjournment.
That's the problem. You take interim order thereafter.
No.
In one pretext or the other. There is no interim order. There is no interim order. There is no interim.
Only a next
the interest of simply like the request of the counsel for the petitioner. Adjourn to so.
Mr. Kanungo is next, my lord.
Whatever. Yes.
Item 159.
My lord, the petitioners are the old parents, my lords, and the affair has been lodged with the son and the daughter-in-law. The earlier case, it was before my lordship.
Yes.
I have prayed for quashing of criminal proceeding, my lords.
The service is complete. Service.
My lords, notice. Notice the judge, my lords. No, nobody has. They're actually the complainants are staying at abroad, my lords, and they're not either appearing in the London court below nor here, my lords.
Notice was issued when?
The on 27/8/24 months.
27.
Notice was issued on. Just.
When notice was not issued, it seems.
It was issued, my lords. I had made them a party. Yes,
6/9. Yes, 6/9. First time notice was issued.
Yes,
earlier notice was not issued.
Earlier, my lords, before in the year 2022, notice was issued, my lords.
When? So which proceeding?
Instructions was called for whether they are appearing or not.
No. Interim order was passed, but no notice was issued.
Yes.
Then it's issued. 20th of January 2023.
My lords.
Nobody appears, huh?
Nobody is appearing.
Yes. Yes, proceed now. Possible.
My lords, the allegation is that, my lords, on the there was
But there is an interim order.
Yes, my lords, there is.
Let interim order continue.
My lords.
Now I have some meeting. Interim order to continue. Non-APS for opposite party despite service. Interim order to continue. Adjourn. Yes. How many
Item 150.
How many
Here I have prayed for quashing of the entire proceeding.
Yes.
But in this case, I have prayed for quashing of the entire proceeding under section 420, 406, 416, 471, 120B. My lord,
Appeal for opposite party.
My lord, I am.
Yes. Are you ready?
My lord.
Huh?
My lord.
Yes.
My lord, initially, a complaint case was filed. Your lordship may kindly have a glance to page 11. The property stood recorded in the name of the father of the present petition.
See, you have an interim order.
Yes.
Immediately after vacation.
My lord.
Second week, interim order to continue. I can't hear it now.
No.
Yes. Interim order to continue. Second week. Yes. Next.
Item 151.
Just run through the list. Otherwise, this thing will be. Wherever there is no interim order. Urgent कर दियो then interim order अच्छी है interim order to continue ठीक है interim order to continue
Item 152, the next item.
Yes.
That is that matter relating to that 138 of the NI Act. Your Lordship, on my mention, this matter is listed. I think this may take some time. My Lord said, yes, he's here. Yeah, I was praying that any time, a time may be fixed after 2 o'clock, 10:30.
Father is given to check or something.
No, the check has been given to the mother. When the mother has given the check in respect of the money which has been received by the son. son who is in custody. My question is that legal enforceable debt, that point, I do have
There is no chance of settlement.
No. My lord, I was praying that previously I had prayed a lot of fixed time so that matter can be disposed of. At this hour, it is not possible. It is not possible.
I have a meeting.
I know. Yes, I know. I cannot insist upon the hearing at this point of time. May I pray your lordship may fix any date subject to lordship's convenience, either first case or 2 o'clock. Yeah.
The 2 o'clock is also, you know, what happened. The time has no meaning.
First case first case subject to your lordship's convenience.
Don't give the dates. I'll just check it up and give the dates. Okay. Adjust करके दे ठीक है. Okay. 152 रख दो. Yes. Any mention?
And can it be taken a fresh admission so that
fresh admission?
Yes. That because previous 2 occasions I made your lordship.
But I have all doubts. See, legally recoverable debt in a 138 proceeding.
Yes.
It is once you pay it knowingly.
Yes.
To discharge some liability. Yes. That liability may be illegal liability, but you know this is the liability of my son, and thereafter you should check. Yes. It is legally recoverable.
That I was having in my mind also, but after I have gone through.
Your son has taken money to give admission in colleges.
Yes, your lordship.
He did not give. A case is registered. He is in jail.
Yes.
And these people came to your house for collecting money.
Yes.
You being the mother of that accused.
Yes.
You should have checked. You should have checked.
Yes.
That check got done.
Yes.
And you are raising the question today. It is not legally recoverable.
Yes.
It is legally recoverable because you knew that there is a liability. That liability may be illegal liability, but the day when you gave the check,
yes,
that day you knew that there is a debt of my son.
But,
so therefore it is illegal.
Yes, but that was in my mind also. That was in my mind also. But I have come across so many judgments, including recent judgments of the Karnataka High Court and
you will have a tough time to answer. Get ready.
direct decision. In order to
give him.
Yes, I had already supplied, and my honored friend also supplied the copy of the judgment which he is relying upon. We both are exchange our pleading and judgments, everything. That your lordship, it will take 15 to 20 minutes for your lordship. Your lordship may fix any date for press admission.
I'll fix it.
My lord,
Entry want to continue.
Item number 156.
Item number 153.
Part number 2. The last order dated 21/8/20.
156.
153. Last order dated 21/8/2024. My lordships, Justice Aditya Kumar Mahapatra had passed an order therein directing that on the appearance of OP number 2, let the matter be referred to the mediation center.
What happened to mediation?
So it hasn't been referred, my lords. It's coming for the first time after that order.
Now, where does it say mediation center?
For mediation on
Party now service is complete.
Lordship,
service.
OP number 2.
Lordship, madam. Pursuant to the order dated 21/8/2024, so entered appearance for opposite party number 2. The coordinated bench of this court, in the order dated 21/8/2024, has recorded that once the opposite party number 2. What is keeping in view the nature of dispute, made clear that on appearance of opposite petitioner has he served and entered appearance in the the matter would be referred to the Odisha High Court Mediation Center. Since the parties have been represented and opposite parties have entered appearance. The conjoint request conjoint request as per the order dated 21/8/2024. The matter is related to so coordinated yes. Awaiting matter.
Lordship, there was
item 187.
In 156 there was
my lord, 161 Miller. That it can after action, the order may be continued. 161.
All entry model will continue.
My lord,
item 187. Date will be given. Yes.
My lord, serial number 159 for press admission. My lord, already 1 year is gone.
Please listed and or supplementary.
What do you want?
Sir, for hearing the matter, sir, for admission, it was.
It will be, or I'll give you a date, what?
My lord,
Revision, this is out of conviction.
No, no, sir, this is challenging the CVI under PML Act.
Not the PMLA. Nobody is there on that side. Yes.
my lord, item 187, it was supposed to be taken up as first item today. Can it be taken up day after tomorrow on behalf of Mr. Deepak Jaina?
You are not there in the morning.
My lord, we are there. We are
At the
there
other side, we are
requested.
We'll see.
Other side requested. So your lordship
Can
can
it
have
be taken
it.
up day after tomorrow or
No, day after tomorrow, my lord.
23rd, my lord?
23rd, your lordship.
23rd.
23rd.
Please.
You are appearing for which item?
187. 187.
23rd, nothing will happen. You know that.
23rd. Then your lordship can have it to 18.
I'll keep it 24th.
My lord, 159, please consider.
24th will be too late, your lordship. 23rd, I'll take a chance.
24th will be one day late. You are asking for 23, I am saying 24. One day only.
Sir, item number 1,
Let
your
it
lordship.
Let it be 23rd.
My lord,
No, practically nothing happens.
my lord, 159, please
Secretary,
consider
item
for
1, your
next.
lordship.
23rd again. Yours also
Yes.
23rd.
Item 157 and 158. Entry model is still.
Entry model will continue. Wherever there is entry model, continue. I'll not. Yes. Okay.
Let's say 153. 153.
Sorry, sir.
153, sir.
153. 153.
Yes. It is
Yeah,
157,
there is no entry order, your lord.
no entry order. It's of quashing filed by the wife against a complaint filed by the father-in-law and mother-in-law. Lordship may keep it some convenient day so that we can come and argue, because right now I am in Bombay.
Date detail. 153 date detail. I'll just keep immediately after vacation.
Yes.
Yes.
I may be pardoned, my lord.
Yes.
My lord, 151, I was appearing. I could not hear what your lordship has just ordered.
151 to Komala. Simply adjourn, madam.
Interim order to continue, my lord.
Entry model.
If there, continue.
If entry model is there, continue. Okay, thank you.
Deeply obliged.